hear oral arguments from Bar Counsel starting first, since it's her motion, and then Mr. Bradl, and then Judge Brennan, in that order. And because the papers were so helpful, I'm going to limit oral argument to about 10 minutes. Does that seem like a fair way to proceed in this matter? Any objections to that order of proceeding? Okay, hearing none. I will say that it's highly unusual.
Bear with me. I believe Attorney Mulvey's raising her hand, but you just need to unmute yourself, please.
Ms. Mulvey.
Hit the microphone button. And Mr. Hoops, her co-counsel, I believe, is going to her rescue. Bear with us one.
Okay, never mind. I found the hotkey. Mr. Cassidy, I'm sure Attorney Brennan appreciates the promotion, but she's an attorney, not a judge.
Oh, I'm sorry. I misread the papers.
That's
sorry,
all right.
Ms. Brennan. Thank you for clarifying. Any objections to the order of the proceeding? Okay. I do think it's very unusual, I will say at the outset, to have a hearing officer resign mid-hearing, as Attorney Sadehi did. But I do not think that I can undo that. I don't think I have the authority to undo that, nor do I think it would be in the best interest of the bar or the public to force anybody to serve on a hearing committee who doesn't want to serve on the hearing committee. So I'm going to take that withdrawal as a given, and as I fashion an appropriate remedy here, consider that as water under the bridge, unless in the oral arguments any counsel disagrees with that premise as well. All right. So first, Ms. Travis, have we already sworn in Mr. Pollack and I'm sorry, our second, Mr. Taylor? Have we sworn in the two hearing officers?
No, they have not been sworn in. I have checked their picture IDs.
Terrific. Well, could we swear them both in now? Sure.
Gentlemen, if you please raise your right hand. I do not see Mr. Pollack. I think it's just the way the screen is.
I saw him a moment ago.
I can see myself, if that helps.
Yeah. I can see him and his hand is raised. There you go.
Okay, now we went to a smaller screen. Okay, gentlemen, do you solemnly swear the testimony you're about to give in the matter now at hand will be the true self you got?
I do.
Thank you.
Thank you very much, Ms. Travis. All right, let's go in alphabetical order. If we could start with our hearing panel chair, Mr. Attorney Pollack. Attorney Pollack, I'm going to ask you just a few questions. If you're unable to answer them yes or no, would you just please explain that you can't answer, and I'll try to rephrase the question?
Of course.
Thank you. The first question is, have hearing officers Sadehi's comments to you in this case prior to her withdrawal, either on the record or off the record, caused you to form a final opinion on the ultimate issues to be decided?
No.
Are you able to listen to the remaining evidence in this case with an open mind?
Yes.
Are you confident that you can remain impartial in this case until the close of all the evidence?
Yes.
Okay, thank you very much, Attorney Pollack. Mr. Taylor?
Yes.
I'm going to ask you the same questions I asked Mr. Pollack, and I'd just remind you, if you can't answer the question yes or no, just tell me and I'll try to rephrase the question.
Okay.
Have hearing officer Sadehi's comments to you in this case prior to her withdrawal, either on the record or off the record, caused you to form a final opinion on the ultimate issues to be decided?
Absolutely not.
Are you able to listen to the remaining evidence in this case with an open mind?
Yes.
Are you confident that you can remain impartial in this case until the close of all the evidence?
Yes.
Okay, thank you, Mr. Taylor. Thank you both for your service in this case. I know it's been 6 days and there are more to come, potentially, depending on how I rule in this case. So I just wanted to thank you both for your service and for your patience. At this point, I think it's best to dismiss you both. because what's left is an argument before the board, and I want you all to have the ability to stay neutral if the hearing resumes in front of you. So I think it's best if you not hear the oral argument.
Sure.
Thank you.
Thank you both for coming today.
Alrighty. Bye-bye.
Bye.
Michelle, have they departed?
Yes, sir, they have.
Oh, terrific. Thank you very much.
You're welcome.
All right, Ms. Harbison, your motion to stay the proceedings and panel a new hearing panel. I'll hear you for 10 minutes.
Okay, I don't think I'm going to take that long, but thank you very much for allowing me this opportunity. And I also want to thank you for your time and for arranging for this hearing. As you know, a hearing committee member, unprompted and unsolicited, made remarks on the record that were clearly biased to Bar Counsel's case. And Bar Counsel at that point had not completed presenting his case in chief, and all of the evidence was not yet in or presented. And so in light of that unprecedented and clearly prejudicial activities that happened made by that hearing committee member, Bar Counsel took the reasoned approach to request that the hearing be suspended so that we could figure out what to do next. And I will also note for the record that there was only approximately 1 hour of scheduled hearing time left at the time that I requested a suspension of the hearing, and no further dates or times had yet been scheduled. So there has not been any prejudice at this time. Despite the hearing committee members' resignation, and I agree with you that that is not something that can or should be undone, Bar Counsel still needed to know more and therefore filed this motion. We have obviously no window into what was said and when and what influence, if any, that had on the remaining committee members. And that's why we're here today, to learn more. And I do want to bring to the chair's attention a recent case from the SJC called Commonwealth versus Vasquez. It was a 495 Massachusetts 279. It's a 2025 case in which there were allegations of bias by a juror, and the court found that the judge was required to make a meaningful inquiry into the statements that were made. And in that case, it hadn't been done. So the murder conviction was overturned and a new trial was ordered. So I'm extremely appreciative of you, Mr. Chair, having taken this matter and this motion seriously, and to conduct a voir dire of the remaining hearing committee members. We're keeping an open mind. We've just now found out, based on their sworn testimony, that they feel that they can continue. And I would like to have a moment or 24 hours of a moment to confer with Bar Counsel should you require anything further from us at this time. Otherwise, I just thank you for your time and for your consideration of this very serious matter.
One question, Ms. Harbison.
Sure.
And maybe you don't want to answer this before consulting with Bar Counsel, in which case I'll gladly give you 24 hours. But to the extent you can answer today, assuming I was inclined to rule against you on restarting the hearing before an entirely new hearing panel, would Bar Counsel have a preference between continuing this hearing before two hearing officers who have already heard 6 days of testimony, or reading in a third hearing officer and reading that person in on the transcripts and having three hearing officers decide the case?
I have no authority to speak on that, so I do want the 24 hours, if possible, to confer with Bar Counsel, and we will file something in writing with respect to that option.
Thank you very much. I appreciate your candor. All right. So, Mr. Respondent Bradl, Mr. Hanley, are you with us?
Yes.
Okay, I'll hear you, sir.
Sure. So,
By the way, before you start, Mr. Henley, I just wanted to say that I read Rule 3.18 to not give me any jurisdiction on your renewed motion to dismiss. 3.18B6 says that once a motion to dismiss has been decided upon by the board chair, it may not be reviewed or appealed other than as provided by the rule, which of course is only respondent's appeal if the motion is allowed. So I don't want an extensive argument on all the reasons why this case should be stopped or your client has been prejudiced by the delay, which I considered very carefully when I decided the first motion to dismiss. Unless you think I'm wrong about my reading of Rule 3.18, that I don't have jurisdiction to entertain a renewal of that motion. I will hear you on that.
Well, as I think you said at the outset, and I'll keep in mind what you're saying to me, but what you said at the outset, this is very unusual circumstances procedurally. We have a hearing that was stopped unilaterally by Bar Counsel. The transcript speaks for itself, but Bar Counsel indicated she was not going to proceed and was stopping the hearing. And I understand that a motion to stay needs to go before the board chair, but no motion to stay was filed for another, 8 or 9 days. And so it's in that posture that we have a stopped hearing, and there's a request for a stay, which is really a request for a mistrial. And what we were saying is that where Bar Counsel has effectively abandoned mid-hearing its prosecution, the case should be dismissed, and we were renewing the motion to dismiss. So in those unusual circumstances, I don't see how it goes before anybody else but you. But I so that's I think how I get there. In this hearing, and part of why we spent time in our memo focusing on it is that if we were here, and as we asked Attorney Sadeghi to return to the panel, but part of that was also to make the point that what she said is no different than what has been said by jurors to court officers and judges, what has been said by judges in bench trials as they sort of try to corral the hearing and try to focus on what is important, that this is no different than what happens in courtrooms all the time. And the rules are obviously loosened to some extent in a proceeding like this, but they're drawn from what happens in courtroom. And we draw from what happens or what our appellate courts decide. And so what she said was not, I would suggest that if she was still on the panel, she would not be required to be removed. And the first step that should have been made was a motion to recuse, which when the respondents moved to recuse this attorney, and ultimately she satisfied us that she could remain impartial based on an issue we raised, the hearing went on. But it should have remained with the hearing committee. But now that we're here with you, we're asking for more. This hearing committee member resigned but did not recuse herself. And I'd suggest that I understand the practical reasons that may be present for not asking her to return, but there's a chilling effect on these volunteers when they're saying, hey, we're going to report, we think what you did is serious, and we're going to go talk to Bar Counsel about that. Other than Mr. Taylor, who's not a lawyer, the lawyers that serve on these committees, we're all licensed by the Commonwealth of Massachusetts. We all have a healthy fear of Bar Counsel. And so when that happens, it sends a chilling effect. And 2 days later, without any motion filed, that hearing committee member resigned. And we'd suggest that is significant. And it's why we went to the step of saying this case should be dismissed. But if not dismissed, and if she's not asked to rejoin, I'd suggest that going forward with the 2 hearing committee members who have heard 6 days of evidence. There are only 4 witnesses who testified over 6 days, and one of them was only, 15 minutes. So it's really 3 witnesses and 6 days of testimony, significant witnesses. The opposing counsel to Mr. Bradl in the trial that's at issue from 20 years ago testified. A representative from the Suffolk DA's office that handled this post-conviction matter testified, and the defense attorney in 2021 that handled Mr. Jenkins' case testified. The ability for these witnesses to have been sized up, where 2 of the witnesses weren't there when the alleged misconduct happened, and one was, his memory was terrible. So the fact that these hearing committee members heard from these witnesses is significant. Their testimony can't be submitted to anybody else. We don't want anybody else to sit on this hearing committee that wasn't there for their testimony. There's a reason we have we have live witnesses. And we wish to, if we have to proceed, and Attorney Sadeghi doesn't rejoin, to proceed with these 2 hearing committee members. It's been great delay in this case, great delay in getting to a hearing, and we don't want any further delay if we must proceed. And so these hearing committee members are the right ones to hear it. There's not going to be better evidence for bar counsel with another hearing. It's going to be these same 2 people who weren't there, and 1 person who has very little memory, no physical file, no electronic file, huge deficiencies in the evidence. And we want the hearing, if it's not going to be dismissed, to proceed with the 2 hearing officers who just told you that they can be impartial.
Okay, thank you, Mr. Hanley. Ms. Mulvey or Mr. Hoops, who do I have the pleasure of hearing from today?
I guess you're stuck with me probably now that I figured out how to unmute.
Okay.
I would echo the feeling that it's incredibly regrettable that we are in this situation. Attorney Sadeghi was incredibly attentive. She asked, as the record will show, many very perceptive questions, showing a command of the documents and the detail. And I think it's hard not to see that she was essentially bullied into resigning by the threat of some sort of public shaming. I'd echo Mr. Hanley's comments about the fear, the healthy fear with which most lawyers view the office of bar counsel. And I think it's an incredibly dangerous precedent to set, to allow hearing officers to be bullied off the committee by bar counsel's displeasure. That said, we're here. I certainly think it would be open to you as the chair to question Attorney Sadeghi, to ask her questions similar to what you asked the remaining 2 hearing officers, and to ask an additional question, whether she feels that any of the events have biased her or made it impossible for her to keep an open mind, and whether she would like, under the circumstances, to retract her resignation and return to the panel. Obviously, I think her answer to that question has to be respected one way or the other, no matter which way it is. But I think it would be entirely appropriate, if she feels like she could come back fairly, and she may not, given everything that's happened, to ask that question and get a panel that's an odd number rather than an even number. With respect to the 2 remaining hearing officers, your questions mirror exactly what a judge would do to a juror in a similar situation. You received appropriate reassurance that they can continue to serve. And again, as with a juror, I think that should be the end of the matter. The Vasquez case, if it's the one I'm thinking of, I believe had a racial overtone to the issue, and it was an issue among jurors.
Oh, well, I'm very sorry about that. As soon as the broadcast ended, unfortunately, the stream cut off. So I'm going to have to load into the archive here and see if we can. I can't believe that happened. What kind of inefficient software or service was used that just cut it off midstream? That's okay, though, because I have two plans to figure out what to do. And it seems like there isn't actually going to be a decision today. This is an argument about whether to stay the proceedings. But I do want to take some time to actually try to, first of all, who runs a tech platform like that? I mean, why would you ever run it that way? Such that the stream just ends. And then it just doesn't go anywhere? All right. I'm not going to give up, though. Hold on here. I'm going to see if maybe it just goes to a different location. I don't know why it would do that. Why would you have a public service that in the middle of a broadcast... Oh, I found it. Hold on. What do you mean it hasn't started yet? Oh, maybe they took some kind of break? Hold on. I'm not gonna be deterred so easily. I'm gonna figure out what happened here. Why can't I just go back to the... Hold on. So we may have actually gone into a recess, which might mean that the event is still going. But as I said, I'm not going to be deterred so easily from finding out what happened in the last 5 minutes of the first part or whatever that was. How can you... Oh, okay. I think I'm not positive, but I think I see what happened. Because they seem to have taken a break and restarted the stream, it looks like... Wait, what? It looks like it's paused. I'm so frustrated by this. What? Maybe they have some sort of system where they have a permanent link. I'm going to have to figure out how that just happened. Because the old recording is a public record. Clearly, it's a public record because it was going. And now it's just not accessible on the Board of Bar Overseers Vimeo. That's outrageous. That is a travesty, a sham, and a mockery. But if you're just tuning in, we are watching the Board of our Overseers hearing with Tim Bradl, and then it paused, and so I am not going to be deterred, though. Oh, I found a backup copy. Hold on here 1 second, folks. So how far in did we get? We got about to Mulvaney's argument, so I'd say about, 22 minutes in or so. So let me just figure that out. 42... Excellent. All right, I managed to find it. All right, give me 1 second here while I pull this up on the screen. It infuriates me that our state system is such that I had to do this in this way. I don't understand how this is possible. I don't understand why there is no redundancy. I'm just incredibly stunned. Just absolutely stunned. All right, so let me try this. All right. Now, where is that thing? Let's see if we can find it. No guarantees here. Oh, there it is. Of course, there's one person streaming it. Oh, look at those towel skills. The state failed us, but social media didn't. Thank you all for your patience. I'm not sure exactly why the state system is that bad.
It's in that posture that...
Hold on, so we're going to jump forward a little bit here because we were in the middle of the
opposing house
arguments.
Mass guide to evidence that
no, a little before that.
Is to retract her resignation and return to the panel. Obviously, I think her answer to that question has to be respected one way or the other, no matter which way it is. But I think it would be entirely appropriate if she feels like she could come back fairly, and she may not, given everything that's happened, to ask that question and get a panel that's an odd number rather than an even number. With respect to the two remaining hearing officers, your questions mirror exactly what a judge would do to a juror in a similar situation. You received appropriate reassurance that they continue to serve. And again, as with a juror, I think that should be the end of the matter. The Vasquez case, if it's the one I'm thinking of, I believe had a racial overtone to the issue, and it was an issue among jurors, that there was some conflict or some strife between jurors that, as I said, I believe has a racial overtone. Again, by analogy to Section 606 of the Mass Guide to Evidence, that has a whole different set of rules. I don't think there's any suggestion that rubric applies here. I also think this is really more analogous to a situation where a judge is sitting jury waived and says something indicating a view of the evidence. I suspect we've all had that happen to us, where a judge says, aren't you going to settle this? Or, counsel, I think you ought to cut that witness short. He's not doing you any favors. All kinds of things got said. As both of us submitted in the papers, there's a legal distinction that's critical between opinions formed as a result of listening to evidence and opinions that are formed based on some extraneous indication or influence. I don't think we have in this case any indication that there was any extraneous influence operating on Attorney Sadeghi or anybody else. With respect to where we go from here, I don't believe that this is asking for a review of a Rule 3.18 decision. I think we have a new set of circumstances with additional grounds that in essence involve bar counsel deciding not to proceed. And I don't think the fact that it's an hour or a day or whatever matters. In essence, bar counsel unilaterally decided she wasn't going to present evidence. And again, my only experience is in a trial court, and I can't imagine that saying that to a judge and getting anything other than a directed verdict. So I do think you have the power to decide the renewed motions given the new grounds. And I'd ask for dismissal, again, because I think this is such an extraordinary situation that from a point of public confidence and getting hearing officers to serve, we just can't let this happen. This just isn't right. And finally, with respect to the 2 versus 3, the evaluation of demeanor, especially where you have witnesses who are not percipient witnesses, but who are in essence giving opinions about things that happened 20 years ago, and drawing inferences, the ability of the hearing officers to observe those witnesses, ask questions of those witnesses, and make judgments based on what happened in the hearing room is irreplaceable, and reading in somebody with a transcript is not a substitute. And as a last point, as I said in the memorandum, there are 100 and some exhibits covering thousands of pages. A lot of the testimony so far involved the hearing committee members following along with a document while the witness testified. So it's not a simple matter of somebody reading the transcript and being caught up. Somebody would have to take the transcript, find the exhibit, match them up, and follow along, which is a far more time-consuming process that I don't think we should subject somebody to. So I think beyond that, I would rest on what we've already said, and I thank you for the opportunity to address you.
Thank you. Ms. Mulvey, one question. You emphasized demeanor evidence. What if we did proceed with 2 hearing officers and they were divided on an essential issue of witness credibility, and they came out on opposite sides of the alleged violation, largely hinged on an assessment of credibility? What would the board do with that on review?
I think that that's a hypothetical situation that I bet we all hope doesn't happen, but would probably be better addressed in real time, knowing what the dispute was. If it were a fairly discrete point, I could envision bringing in a third tiebreaker and repeating or having a witness testify for, a half hour or whatever it took to resolve that specific point. I think it's so fact specific that it would be better not to speculate about what we do and preferable to address it if and when it happens.
All right, thank you. Ms. Harbison, I do have one final question for you. How many more witnesses do you anticipate calling, or if you would prefer not to answer the question that way, what percentage of your case do you think these 6 days of testimony have already taken up?
I have a couple of points I'd like to make on that question. The first answer, the straightforward answer is I have both respondents that I'm planning to call as the final 2 witnesses. So
you think you have 2 more witnesses?
2 more witnesses. Okay. Yes. But I would like to point out that the reason, if you look at the transcripts, that this hearing has taken such an extraordinary amount of time is not due to Bar Counsel's presentation of the evidence. It is due to the respondents asking the same question 5, 6, 7, 8 times and going down rabbit holes that I find objectionable. I've made the objections. They've been generally overruled and everything's come in. So that's just the way that this hearing has played out. But to place it on Bar Counsel and saying that I refused to proceed when I was saying that I wanted to have the hour to discuss with Bar Counsel and that we could pick this up after this board decided on whatever we decide, the motion we decided going forward. So, I also think the ad hominem attacks on me as being a bully and causing Attorney Sadeghi to resign is inappropriate and untrue. And finally, I would say that Attorney Sadeghi said on the record that she had made these statements after the first day of hearing. There was almost no evidence presented on the first day of hearing. That was because the respondents had decided that some private correspondence between the defendant 20 years ago and his trial counsel, correspondence between them, which was protected by attorney-client privilege, should be turned over. And there was much argument about this. And so that's what took up the majority of the first day. So, and then Attorney Sadeghi said she had made comments after that first day. So it wasn't in response to any evidence that Bar Counsel presented. This was clearly something she had made her mind up upon reading the petition, or just because she, whatever, I don't know what the reasons were, but I just really feel that needs to be clarified. Thank you.
Thank you. Mr. Hanley, Ms. Mulvey, any objection to giving Bar Counsel 24 hours to answer my question in writing as to the 2 possible alternatives here after consulting with Bar Counsel?
No.
Mr. Hanley? No.
And Mr. Chair, may I add one additional comment to Ms. Harbison's comments?
You may. Can I just finish my thought?
Absolutely. Sorry.
Thank you so much. Ms. Harbison, in your writing that you're going to file tomorrow, please limit it to the question of how to proceed, assuming we proceed. I don't need a regurgitation of that we should start the hearing over. I've heard you on that, and I've been the beneficiary of your papers.
Okay, thank you.
Yeah, Mr. Abadi.
Thank you, Mr. Chair. I did want to add some comments, particularly with respect to Ms. Harbison mentioning references to bully, references to intimidation, references in papers to a gorilla. I first want to fully echo and support Ms. Harbison and her arguments in this case. But I also want to address very briefly the comment that what this proceeding and this motion stands for. I take very seriously the bar discipline process, and I do want to comment that this motion was filed in reference to that. Our profession is largely self-governed by lawyers, while non-lawyers from the public have some voice in the bar discipline process, and it's a very important voice in helping us decide which lawyers should have their licenses restrained in some way. The signature of the bar discipline system, one that I am very proud of, is that we lawyers, we hold each other accountable. And for this system to work, it must appear beyond the reproach to the outside world. I can tell you that I personally regularly hear from clients who feel let down by this bar discipline system because they feel like it's an insider's club, a club where lawyers won't hold their peers accountable. And we, as stewards and protectors of the bar system, we have to fight that appearance at every turn in the system. So I would venture to say that it should not be controversial to say that a hearing officer who displays deep-seated favoritism or antagonism towards one side's case in the middle of a hearing should not continue in that case. And I would rely solely on the comments in the record from the hearing officer who has recused herself to decide whether those comments, particularly with respect to maternity leave and bar counsel's case, reflected some bias. I would say that it is obvious that there was some deep-seated favoritism or antagonism towards bar counsel's case. Now, I would say that that is what bar counsel was presented with when these comments were made totally unprompted, totally uninvited on the record. And she revealed these deep-seated sympathies towards Respondent Brennan's case. Any party on the receiving end of such personal antagonism towards their case, whether it is the Office of Bar Counsel or Respondent's Counsel, certainly in those circumstances would feel that they would need to respond with a motion to recuse that hearing member. And if that hearing member also volunteered unprompted that they made comments off the record in private to other hearing committee members, I would venture to say that any counsel in that situation, whether they be bar counsel or the respondent, would feel absolutely compelled to file a motion to stay the proceeding, to recuse the hearing panel members, and have an opportunity to at least inquire as to what happened. What is the basis of these comments? How are these comments shared with the hearing panel members? What were the hearing panel members' reaction to those comments? And the SJC case that was cited is a perfect example of why it's important to hold a proceeding like we're having today. And Mr. Chair, we appreciate that you calling this proceeding. We think it was a thoughtful, appropriate response to our motion. We appreciate the testimony that was given today. I will meet with Ms. Harbison immediately after this proceeding, and we will submit something within 24 hours. But I object on the record to the suggestion that the premise of the motion somehow is something that my office or the bar discipline system has to be embarrassed of or remorseful of. When I would submit to you, it's the opposite. We are doing our best to make sure that what we represent and what we put out to the public and to the bar is something that that we can all be proud of. So thank you, Mr. Chair.
Thank you, Mr. Abadi. Mr. Hanley, anything further?
No, thank you.
Ms. Mulvey, anything further?
No.
Ms. Harbison?
No, thank you.
Okay, thank you all for your time today. Thank you for accommodating your schedules. I expect you'll hear from me very shortly. There is no next date for this case. Is that correct?
Correct.
That is correct.
So you'll be here.
Well, folks, what an interesting series of developments. Firstly, we just got to the end of the hearing, but I want to explain to you a little bit of what I think just happened there. I think that, just to pull folks back and explain what's happening, there is a discipline system for attorneys in Massachusetts and in every state, but in Massachusetts, called the Board of Bar Overseers. Well, that's what it's called in Massachusetts. Now, I'm going to bring up for you a overview, I thought I had it, of the case that resulted in this discipline. I have it. Yep, here it is. And there's actually a substantial amount of background. But what I want to explain is procedurally how this works. To understand this, you kind of have to understand administrative law a little bit, because the Office of the Bar Counsel has like what you would call an enforcement function, and then walled off within the agency is an administrative ALJ-like hearing officer function, okay? Administrative law judge. Now, what was being discussed in that hearing, which is quite abnormal for the taciturn environment that is the Office of the Bar Counsel in Massachusetts, what was being discussed there, which really, really blew my mind, was that the Bar Counsel brings a complaint against a lawyer, okay, against the lawyer. In this case, it was two lawyers, Tim Bradl and a woman named Lynn Brennan. And in the context of bringing that complaint, what happens is there is a hearing in front of the hearing officer that I just mentioned. Okay, so let's bring this up. Okay, there we go. That's the Justice for Sean Ellis site that has the overview of this story. If you want to learn more, that's a good URL to follow. Bradl and this woman, Lynn Brennan, who were prosecutors on this case and were alleged to have committed serious misconduct and withheld very important evidence and lied about it to the court, were brought in front of a tribunal, the Board of Bar Overseers. The Bar Council, a board of hearing officers that's kind of lower than the Board of Bar Overseers. There were three hearing officers. Right away, apparently, there was concern by the Bar Council that one of the hearing officers was biased, engaging in ex parte communication, and had rendered opinions about the case about Brennan and Bradl that were prejudicial to the Bar Council. And what then at the end happened there was the Bar Council, when there must have been the actual Bar Council compared to a sort of assistant Bar Council that was arguing to begin with, came on, that was the man at the end, and said, there are already concerns that this body of legal discipline is not acting in an authentic way because there's too much inside baseball. And although he didn't say it directly, that human being basically was saying that there was concerns by the Bar Council that Bradl might have somehow impacted, or Lynn Brennan might have impacted, or their lawyers, the fairness of the process by somehow impacting the bar examiners. The actual hearing officers that were listening to the case being presented by the Bar Council. Now, what you saw today was very rare, because what it basically was the Bar Council, when this hearing officer resigned, and by the way, there was a little bit more here, but I'll explain it in a second. The Bar Council, when this hearing officer resigned, did something extraordinary, which was, one, the right thing. Before the hearing officer resigned, the Bar Council, in light of this extraneous or this extra judicial influence, put forward a motion for the member of the the hearing officer to recuse themselves. And I think that hearing officer did, but then they resigned from the entire process, from the whole apparatus, the agency, mid-hearing. That caused Bar Counsel to file a motion to stay proceedings with the chair of the Board of Bar Overseers, and that is what was just heard. That's what we just watched. It was a public hearing on the motion by the Bar Counsel to stay proceedings, and then the Bar Counsel, I think, was asking for the proceedings to restart, and Bradl and the other lawyer, Lynn Brennan, through their counsel, were arguing for the proceedings to keep going. And I kind of got the sense that maybe this proceeding as it was existing was very biased against the Bar Counsel. And that's just shocking, the implications of that. But there was no decision rendered by the chair of the Board of Bar Overseers here. But what was shocking is that what came up was there was allegations that someone referred to the assistant bar counsel or the bar counsel, whether they're assistants or just all bar counsel, I'm not sure, as a gorilla, and was making remark. The hearing officer made remarks about bar counsel's maternity leave in the middle. Like, what? How could this have happened? There's something clearly. There's something really serious bubbling under the surface here. I'm glad that I watched that. I don't know if the state just accidentally made it so that the hearing reset and just wasn't available, but managed to catch half of it and then caught the rest of it. That was pretty explosive. There's something going on there, and I really think the Bar Counsel is in the right here, and that there was something really weird with how those hearing officers were acting towards either Bradl or Lynn Brennan or both, in particular favoritism towards Lynn Brennan and Tim Bradl at the expense of Bar Counsel in a fair process. And remember, this is a referral, I'll read it to you, that went over from a Superior Court judge. And I will, I'm going to have to zoom in a little bit here, but I'll read it for you. Hold on a second. Where am I now? All right, so let's see. It's at the... let's see. Do we actually get a summary? It ended with... The part that I had found the other day was such a good summary because it had a quote from the judge in the case in 2021 referring Bradl and Lynn Brennan to the BBO for this investigation. So it wasn't this was more, although the Bar Counsel was saying citizens rely on this process to have integrity, this was a judge referring Bradl and Lynn Brennan here. And I will say, maybe it was really, really down in the article, but I will say, I think it actually was, now that I think about it. But I will say something is going on here. I think something is, I'm not exactly sure, but I think something may have been going on there with, and remember, this has to do with Bradl and Lynn Brennan put out a statement in relation to Sean Jenkins's case saying that, is it Sean Jenkins? But Sean Ellis? I thought maybe the victim was Jenkins. But the point is the same, that the Bradl did very serious things in this case. Not only did the original prosecutor, Lynn Brennan, file a note saying that there wasn't enough evidence to indict, but then, as I explained in the pre-show, serious exculpatory evidence for the defendant, which showed that another person was tormenting the victim over a drug debt in the hours leading up to the death of the victim, was never provided to the defendant. And eventually, after 15 years in prison, the defendant was freed. But this is not a low-level case. And as I said, the Bar Counsel got this referral from a judge. So it is really, really shocking to me. Of course, I'm reading the reason that this wasn't what I was looking for is I was reading this. I went on a different research path last night about the murder of Boston police officer Sean Mulligan, which was another. I see how I got confused because it's SEAN and SHAUN. But let me pull up the U Michigan link that I had, because I think that is actually far more important. But let me not get myself distracted here, because there was, yes, I found it. So please forgive me for that slight delay, and you will see how easy it is to get distracted. Not distracted, but I was going on a very in-depth research drive last night, and I was involved in 2 cases with very similar themes of prosecutorial misconduct. And needless to say, let me bring us back to Sean Jenkins' case, which is what Bradl was involved in. So let's go on December 20th, 2021, Judge Salinger vacated Sean's conviction and granted him a new trial. The judge cited the cell phone records as well as the evidence the prosecution had gathered regarding Mike White and Stephen's unpaid debt. The judge noted that the prosecutor had written an internal memo documenting that evidence. The prosecution was not required to share the entire memo, the judge noted, but once the prosecutor learned that detectives had gathered exculpatory evidence confirming Stephen's drug debt, the identity of his drug supplier, and where the supplier lived, she had an obligation to have that information put in writing so she could turn it over to defense counsel. Justice was not done, Justice Salinger declared. The Commonwealth denied Jenkins fair trial. The conviction of first-degree murder is seriously tainted by the Commonwealth's misconduct and should not stand. Justice Salinger also ruled that he had an ethical obligation to report the conduct of the prosecutors who withheld evidence, Bradl and Lynn Brennan, and lied about it in court to the Massachusetts Office of the Bar Council, which investigates allegations of lawyer misconduct. So that's what I'm saying. I was not understating in any sense of the term the severity of this. And so coupled with this perception and a public argument from the Bar Council that there may have been undue extraneous influence by either Bradl or Brennan or Lynn Brennan or their lawyers on the hearing officers, that was stunning. I can't believe that just happened. I can see this kind of public hearing happening on a motion to stay, because really the question is, should the board chairperson bring in a new hearing examiner, start the process over? We also found out Bradl apparently tried to dismiss this this investigation already and lost on a ruling from the chair himself. But my word. The implications of it are astounding. I'm processing it with you all now. I kind of thought maybe we'll see a ruling or something. I did not expect that. Now what I'm going to do for you, by the way, because there are that is enough to take in, but we don't actually have a resolution to that. We just have the general insights. But what I'm going to do for you is 2 things. One, I'm going to take a look on the on Pacer, and I'm going to see if we can find if anything happened in the Karen Reed appeal. So I'm going to because Karen Reed tried to submit a motion to stay her state level case despite having lost her previous motion to stay. She filed an original motion to stay in the lower federal court, the district court in Massachusetts, and now she's filing one in the federal court. Nothing yet on the ruling on the motion for stay. I expect it to come down pretty soon. The Commonwealth also filed its response brief, which is 58 pages. Let me take a look at some of the YouTube comments, by the way, and let's see what, if anything, I have to say to all you wonderful friends. Hello, Maui Swift. Very good to see you all. Let me see here. Grant, this is hilarious. Oh, yes. Right, there was round-trip airfare murder by Maestro of $100 to one of the. There was round-trip airfare and payments to one of the witnesses that was not disclosed to the defense in the Sean Jenkins case. And Bradl was a prosecutor at the time. All right, let's see. Is it true TurtleBoy released Hank's address and phone number? Can he get in trouble for that? TurtleBoy did release Hank Brennan's home address. That was a bit of a strange thing, not something I expected to see. Yeah, there was a post on social media. TurtleBoy threw it up in the middle of posts about March Madness and just put up Hank Brennan's home address. And then a lot of people were saying, and just to take a moment to comment on this, people were saying, well, that's not doxing because you can find that on Google. And it's like that. First of all, did any of you read the JFK files? The government by accidentally released social security numbers of like 100 very like important people. like just by accident, because they were releasing all the documents in the JFK files, and one of them had social security numbers in them, and they just released it. So that's on Google. Like, is that something that, no, of course that's docs. It's the epitome of releasing docs on someone. And it's very similar with other private information. The overlap between private and public information is not what determines whether something is docs. It's whether you're sharing it in public with either overt or covert malicious intent, such as driving harassment or swatting or whatever it may be, infamy or shame or whatever it is. Hello all, good to see you, Barb, good to see you, Lisa Cox, and Goldie Lawrence. Yes, let's see what else we got. Trevor says he read Kayla Schillinger's rebuttal. It was an absolute gem and destroyed Reed's arguments from every single angle with solid case law. All right. Are you really saying that what you would like us to do is impromptu, in the middle of a stream when I was going to write up a post about what happened with Bradl, you would like me to go through the 58-page document from Caleb Schillinger's reply? Is that what you're saying? Because, I mean, I can do that kind of thing. I am a towel. And that should... Oh, look at that. I'm a handy, useful towel. Now, give me 1 second while I make this somewhat more legible. And then also you have to sit with me while I write this post as I explain it to you out loud, because we're going to get the Bradl thing done. The last thing I wanted to do today was do a 58-page document read. But you know what? We're going to do it. We're going to do it because you all are wonderful people, and you deserve to learn about how badly Karen Reed is going to lose at the First Circuit Court of Appeal, and also because I love Lawrence v. Stearns, Tanner v. U.S., Pena Rodriguez v. Colorado, Bluford v. Arkansas, and every single case within that progeny. It just speaks to my soul as to the inviolability of jury deliberations, even in light of allegations that jurors were using drugs. I think it's because one day I could envision myself thinking about the constitutional ramifications of such a question and thinking, I truly enjoy the sardonic undertones that are latent within my consideration of this highfalutin legal issue while talking about jurors using drugs. I think the position juxtaposition is a wonderful explication and microcosm of the heart and soul of the American justice system. And also that speech by the Bar Council about how lawyers try to influence hearing officers in the Bar Council process. Two heads of the same seven-headed dragon? All right, I'm doing this post. I'm telling you, I am a friendly, wonderful... Oh, Reneco. Yes, that's a great Reneco. We're going to get to talk all about Reneco. Did I tell you, Trevor, when I was in federal court, I think I was the only person furiously scribbling notes for the entire 2 hours of oral argument. Oh, and also Justice Saylor gave us a stretch break, and he didn't give us a recess. He said after the Reed defense finished their oral argument, he had us stand up and said, "Okay, it's time for us to stretch, everyone," and then he led us in a stretching exercise. It was really a quaint moment in many regards. But yes, Judge Saylor hammered Reneco home throughout his questioning of, I think it was Marty Weinberg, on reply after Caleb I cannot say this name, I'm sorry. He said it in court the other day. I struggle to pronounce names that are far more simple than that in some regards, so I'll get it. Schalinger? He'll say it in court. I'll get it. But the point is, that argument between the judge, the questions, but the colloquy between the judge and Marty Weinberg about Reneco was really, really at the heart of what was going on. Okay, but as I said, the two prices you pay are, one, every hour or so you get a moment of levity when listening to these streams, and two, you get what I would call a public information service announcement, which is, this is a user-funded public information service, and while I'm absolutely happy to read 58 pages for you, I actually paid $3 for this document. And I have been downloading a lot of documents, and I also don't really have enough money to get through the end of the month. So If you want to support these streams and help me offset server costs and all those other things, your donations are greatly appreciated. But as always, the disclaimer is, although you are supporting this public information service and therefore allowing others to continue engaging with the content provided thereupon, really what you're doing is speaking to the democratization of participation that I try to encourage, because as noted, you do not need to send a donation to ask a question. And in fact, if you send a donation and try to imply that you somehow have priority, I'll be like, well, no, but if you just send a donation with a question and I see it and you don't ask, I'd be like, well, that's the same as sending a regular question. But no, that's the one thing that I think is very important, which is that there's no hierarchy here. If you leave a comment or a question and it's not derogatory or otherwise insulting, and you know what, we'll even waive our Kate Peter exception today, no being derogatory or discriminatory at all in any regard. And in that context, you can say your comments and your questions, and if they have merit, I will read them. There is no hierarchy based on your ability to provide a donation. It just helps support keeping me alive, I suppose, which is good, because if you all just leave Towel to his own devices, I will go walk out in the countryside, I will don some kind of robe, and I will walk around preaching to people, and then eventually I'll run out of fresh fruit. I don't even like fruit. I'll run out of people who just give me food, and then I will die. And I don't think anyone wants that to happen to Towel. Towels are wonderful, absorbent, and full of life and hope, even in the face of the most desolate despair. And so isn't that not a worthwhile soul to keep alive? All right, now I actually have to write the post about Bradl. I'm sorry, I delayed it as long as I could. You all must pay this price. It's not actually really a price, though. It's more just me typing for a little bit on the computer. And if anything, you can listen to how I form my posts when I'm thinking, because a lot of people are like, Grant, how do you do that? And although this one isn't necessarily one that I'm going to edit, what I am going to do is I'm going to talk you through my writing process. The editing process right now would take too long. I wrote a great post earlier. Maybe I'll read it for you all if I still have voice after 58 pages. Where I did this, I was using Casablanca as kind of the hook, and I wrote this really good multi-layered illusion that involved like Nenya's 99 Luft balloons and a lot of allusions to like the last days in Berlin, but none of it was explicit. And I even referenced like Rousseau's garlands of flower argument from the first discourse. That's the type of stuff that I like to really edit. This I'm going to write in real time, and we'll talk about it. All right. Okay, so here we go. How shall I express this? Well, first I want to mute it, and then, so let's do it this way. Just in. There is serious trouble brewing within an ongoing case at the Massachusetts Board of Bar Overseers involving Tim Bradl, the attorney for Aidan TurtleBoy Kearney, and Bradl's actions that resulted in an innocent man spending 15 years in prison. I should say Bradl's actions as a prosecutor. That's a good lead. Now, what I'm going to do next is I'm going to say, during an explosive segment of a rare public hearing involving the state's bar council in charge of employee discipline, on, what day is it? Monday. On Monday. In charge of, not employee, in charge of lawyer discipline in the Commonwealth. On Monday, the chair of the BBO was told that there was indications that a hearing officer involved in Bradl's case was exposed to external influence, was exposed to external influence, bias against the bar counsel during proceedings, and made remarks about bar counsel's pregnancy leave during the pendency of said proceedings. I forgot about how fucked up that part was. Who the fuck does that? That person's going to get in serious trouble. Isn't that kind of a violation of the Family Medical Leave Act? About pregnancy leave during the pendency. Then, in further shocking moments, it was revealed that someone, it wasn't actually clear who, that someone involved in defending either Bradl or his colleague facing discipline, Lynn Brennan, referred to bar counsel as a gorilla. What the hell? That part was also like, what the hell? It was really... in further moments that were made public on Monday, it was revealed that one of the 3 hearing officers on the Bradl case, after those remarks, was subject to a motion to recuse by the bar counsel. After acceding to the recusal motion, the hearing officer then resigned mid-hearing. I'm not going to deal with that right now. I dropped my lighter. Is this yep. All right. The hearing officer then resigned mid-hearing. At that point, bar counsel, let me see if this is, sometimes people message me and then I'm like, why are you messaging me right now? And then it turns out to be very important. Is this going to be actually very, very important? Exactly. Okay, so, yeah, to the person that just messaged me, you should post that. I have to finish my post about Tim Bradl. At that point, bar counsel then moved to stay the proceedings in a written motion that was submitted to the chair of the BBO. In turn, that motion to stay proceedings, and I think it's really restart the full hearing process in front of a new board, board of hearing officers. In turn, that motion to stay proceedings or restart the full hearing process in front of a new board of hearing officers was heard today in public by the chair of the BBO. During arguments I actually have to figure out what this guy's name is, because I wonder, maybe they're all bar counsel, but is he like the bar counsel? Is there a specific bar counsel? All right, let's see. So is it this one? No, it's not that one. Is it this one? Yeah, I think it was this one. All right, so I have to just make sure this is going to be the right video, so apologize. You're going to hear a little bit of sound here, which is just the same video we watched earlier.
Witnesses, do you anticipate calling, or if you would prefer not to answer the question that way, what percentage of your case do you think these 6 days of testimony have already taken up?
Asking the same question.
Oh, okay, so that's what we want. Let me just see if we get to the end here.
The motion somehow is something that the
Okay, so I have the video I want. During argument, during argument. Oh, that's what I wanted to figure out. What is this man's name? Because if he has some high-ranking position, the gentleman who came on there at the end, who gave that eloquent speech in defense of the integrity of the Office of Bar Counsel, that actually has very, very big relevance. Also, you're kind of watching how I put together a story or do my research in real time. I don't really think of it like that, but I guess that's kind of what I'm doing. All right, what is your name, sir? Richard Albus? Abus? All right, let's do some Googling. I'm going to figure out this gentleman's name, and then we'll have time to start this review of this document. It looks like Richard Albus. No, that was not even close. Richard something? Oh, Richard Abadi. Is that what it is? Is it Abadi? Hold on, I'm going to need to actually do some investigations here. Why can't I zoom in on this? This should be far easier for me to do here. What is your name, sir? Richard, is that what it is? A-B-A-T-I. Yeah, I'm pretty sure it's Richard Abadi. But it does. Who is Richard Abadi? Let's see. Acting Bar Counsel. But what does that mean? Let's see. I'm going to have to do. Is there just one? I mean, are there a bunch of other bar counsel, but is he the one of the first? Oh, found an interesting article about him. Who's a body? No, I don't want it. I do not want that. Let's see. A body is serving as acting bar counsel. I'm just going to ask, who is the bar counsel in Massachusetts? He is. That was him. That was the guy. Well then, I'm glad I did that research. I'm a towel. Look at me being all towel-like and doing these things in real time. Hold on one second. Richard Abadi. I'm typing here. Richard Abadi. This is so fascinating. The bar counsel himself even made an appearance at the end of the hearing in defense. Hold on, I have to phrase this exactly right because his argument was extremely eloquent. In defense of the integrity of the bar counsel's process, and furthermore hinting that public distrust in the bar counsel process exists, is rampant because of the very allegations of inside baseball that, although not explicitly addressed, seem to be underlying the emergent concern expressed by bar counsel expressed by Abadi and his colleagues at today's meeting, at today's public hearing. Now I need to go for a second here and actually find this man's quote, which then I am going to type for you as he says it. So you all are going to get to listen to it one more time as a refresher, and then I'm going to type it, and then we're going to move on.
Our profession is, but I also want to address very briefly the comment that what this proceeding and this motion stands for. I take very seriously the bar discipline process, and I do want to comment that this motion was filed in reference to that. Our profession is largely self-governed by lawyers, while non-lawyers from the public have some voice in the bar discipline process, and it's a very important voice in helping us decide which lawyers should have their licenses restrained in some way. The signature of the bar discipline system, one that I am very proud of, is that we lawyers, we hold each other accountable. And for this system to work, it must appear beyond the reproach to the outside world. I can tell you that I personally regularly hear from clients who feel let down by this bar discipline system because they feel like it's an insider's club, a club where lawyers won't hold their peers accountable. And we, as stewards and protectors of the bar system, we have to fight that appearance at every turn in the system. So I would venture to say that it should not be controversial to say that a hearing officer who displays deep-seated favoritism or antagonism towards one side's case in the middle of a hearing, that appearance at every turn in the system. So I would venture to say that it should not be controversial to say that a hearing officer who displays deep-seated favoritism or antagonism towards one side's case in the middle of a hearing should not continue in that case. And I would rely solely on the comments in the record from the hearing officer who has recused herself to decide whether those comments, particularly with respect to maternity leave and bar counsel's case, would rely solely on the comments in the record from the hearing officer who has recused herself to decide whether those comments, particularly with respect to maternity leave and bar counsel's case, reflected some bias. I would say that it is obvious that there was some deep-seated favoritism or antagonism towards bar counsel's case. Now, I would say that is what bar counsel was presented with when these comments were made, totally unprompted, totally uninvited on the record. And she revealed these deep-seated sympathies towards Respondent Brennan's case. Any party on the receiving end, totally uninvited on the record. And she revealed these deep-seated sympathies towards Respondent Brennan's case. Any party on the receiving end of such personal antagonism towards their case, whether it is the Office of Bar Counsel or Respondent's Counsel, certainly in those circumstances would feel that they would need to respond with a motion to recuse that hearing member. And if that hearing member also volunteered unprompted that they made comments off the record in private to other hearing committee members, I would venture to say that any counsel in that situation, whether they be bar counsel or the respondent, would feel absolutely compelled to file a motion to stay the proceeding, to recuse the hearing panel members, and have an opportunity to at least inquire as to what happened. What is the basis of these comments? How are these comments shared with the hearing panel members? What were the hearing panel members' reaction to those comments? And the SJC case that was cited is a perfect example of why it's important to hold a proceeding like we're having today. And Mr. Chair, we appreciate that you calling this proceeding. We think it was a thoughtful, appropriate response to our motion. We appreciate the testimony that was given today. I will meet with Ms. Harbison immediately after this proceeding, and we will submit something within 24 hours. But I object on the record to the suggestion that the premise of the motion somehow is something that my office or the bar discipline system has to be embarrassed of or remorseful of. When I would submit to you, it's the opposite. We are doing our best to make sure that what we represent and what we put out to the public and to the bar is something that we can all be proud of. So thank you, Mr. Chair.
Thank you, Mr. Abadi. Mr. Hanley, anything further?
Those were some quite powerful comments. I'm glad I was able to type them. I'm sure you heard me furiously typing in the background there. I was able to get, other than the point where I had to replay it a few times, I was pretty much able to keep up with how fast he was talking. He was saying some pretty complex stuff. Said Abadi. Abadi continue. Oh, hold on, let me bring you with me for this drafting process. Abadi continued in what could go down as, I'm not saying seminal Alan Jackson, as a speech for the ages from bar counsel, depending on how this series of events plays out. So now I have to say, in those shocking moments, it was revealed that someone, either Bradl or his colleague facing discipline, Lynn Brennan, or their lawyers, referred to bar counsel as a gorilla. Behind, oh, now I have to explain it because I wrote that great quote now. Behind these shocking moments that were made public on Monday was a series was the result of a 6-part process in front of 3 hearing officers on the Bradl. Behind those shocking moments that were made public on Monday was were the result, not was the result. Those shocking moments that were made public on Monday were the result of a 6-part process in front of 3 hearing officers on the Bradl and Brennan case. After those remarks, all right. Occurred during. All right, so now I have to just explain the end of the hearing, and I'm done. As a result of today's hearing, the chairperson of the BBO gave bar counsel 24 hours to propose a path forward as to how the hearing involving Bradl and Lynn Brennan will continue. The chair of the BBO also noted Bradl's previous attempt to dismiss the ongoing complaint was denied by the chair himself. All right, so that's good. Now all I have to do here is just add a little background about a very important background about the case and Bradl's misconduct, and then we're done. That was, and I'm sorry I had to take you through that writing process, folks. I hope you at least benefited from it some. I wanted to make sure that if I was going to write up what we just saw happen, I wanted to do it in a way that would be able to inform people who didn't actually watch the stream. So I realized that for you all it may seem like that was a little bit redundant, but I also feel like there was an incredibly valuable piece of information. Background. All right. Thank you. All right. Perfect. This is exactly what I wanted, so give me 1 second. All right, I got the full background there. I ended it with a link to Sean Jenkins' U Michigan page. And I'm sorry I didn't get confused, but I'm sorry I was looking into the Sean Ellis situation last night because that took me down a rabbit hole that I really did not expect. And then the text was so small, I was like, why is this article not what I want? All right, so I have the full clip there. I'm going to... there's a serious trouble brewing within an ongoing case at the Massachusetts Board of Bar Overseers involving Tim Bradl, the attorney for Aidan TurtleBoy Kearney, and Bradl's actions as a prosecutor that resulted in an innocent man spending 15 years in prison. As a former... I think as a prosecutor is fine. During an explosive segment of a rare public hearing involving the state's bar counsel in charge of lawyer discipline in the Commonwealth on Monday, the chair of the BBO was told that there were, that is tense verb confusion, were indications that a hearing officer involved in Bradl's case was exposed to external influence, bias against the bar counsel during proceedings, and made remarks about bar counsel's pregnancy leave during the pendency of proceedings. Richard Abadi, the bar counsel himself, even made an appearance. So I think what's important to explain, I think we're going to call that assistant bar counsel. I think because Mr. Abadi, I do not think was pregnant. Richard Abadi, the bar counsel himself, even made an appearance at the end of the hearing in defense of the integrity of the bar counsel's process, and furthermore, hinting that public distrust in the bar counsel in the legal discipline process is rampant because of the very allegations of inside baseball that, although not explicitly addressed, seem to be underlying the emerging concern expressed by Abadi and his colleagues at today's public hearing related to what happened during the Bradl and Lynn Brennan proceedings. Then I did the quote. I take very seriously the bar discipline process, said Abadi. Our discipline is largely self-governed by lawyers, while non-lawyers from the public have some voice, and it is a very important voice in helping us decide which lawyers should have their licenses restrained, not retrained, restrained. In some way, the signature of the bar discipline system, one that I'm very proud of, is that we lawyers, we hold each other accountable. And for this system to work, it must appear beyond reproach to the outside world. Abadi continued in what could go down as a speech for the ages from bar counsel, from any bar counsel. Depending on how this series of events played out, I regularly hear from clients who feel let down by this bar discipline system because it's an inside club, a club where lawyers won't hold each other accountable. And we as lawyers have to fight that appearance at every turn. And in turn, it should not be controversial to say a hearing officer who displays deep-seated favoritism or antagonism towards one side's case, so there was a comma there, apostrophe, one side's case in the middle of the hearing should not continue in that case. And I will rely solely on the comments on the record from the recused hearing officer to decide whether those comments, particularly as to maternity leave and bar counsel's case, reflected some bias. Bar counsel is a proper noun. These comments were totally unprompted, totally uninvited, and on the record, and the hearing officer revealed deep-seated, is it seated? Deep-seated? Deep-seated hatred. Is it really deep-seated hatred? Oh. It's really deep-seated, S-E-A-T-E-D. I can't believe I got that right. Deep-seated. I hope I didn't say seated before. I did. I said deep-seated. Now I have to go correct that. Do you see how much editing I have to put into these? And this isn't even one of the ones that I'm really, really putting editing into. This is just a very perfunctory surface level edit. I spent hours on some of those posts that are like 3,000 words. All right. So deep-seated is a contraction. So let me just go down to the other deep-seated now and make sure that's a contraction. All right. So both of those look good. Favoritism or antagonism towards one side's case in the middle of the hearing should not continue in that case. I used it 3 times. No, just twice. These comments were totally unprompted, totally unnecessary, uninvited on the record. And if that hearing member also volunteered that they make comments off the record to other hearing committee members, any counsel. Oh, it was a hearing committee member. And if that hearing committee member also volunteered that they make comments off the record to other hearing committee members, any counsel, whether bar counsel or respondent. Oh, dear God. I'm correcting capitalization, would feel compelled to stay the proceedings, recuse the hearing panel members, and to inquire as to what happened. What is the basis of these comments? How were they shared with the other hearing officers, and what were their reactions to these comments? In further shocking moments, it was revealed that someone involved in defending either Bradl or his colleague facing discipline, Lynn Bradl, or their lawyers, I'm just going to say someone, either Bradl or his colleague facing discipline, Lynn Brennan, or their lawyers, because we don't know who, is an unattributed to statement referred to bar counsel as a gorilla. I'm not really sure why someone would refer to bar counsel as a gorilla. In pleadings, in an argument, I just don't think there's ever an appropriate opportunity, ever a situation where you should refer to bar counsel as a gorilla. I just can't imagine how that even happened. These shocking remarks that were made public on Monday occurred following a yet to be completed 6-part process, yet to be completed 6-part process in front of 3 hearing officers on the Bradl and Lynn Brennan case, in front of 3 legal disciplinary hearing officers. Is that how you spell disciplinary? Nice. After acceding to the recusal motion, the hearing officer in question, who then resigned mid-hearing. At that point, bar counsel moved to stay the proceedings in a written motion that was submitted to the chair of the BBO some days later, which I think it was the appropriate procedure because clearly the chair had a hearing. In turn, the motion to stay proceedings and restart. Do I actually have to get my phone? What has happened? Has something happened where I actually need to address something? As a result of today's hearing, the BBO gave... no, nothing. Not that I can see anyway. Okay. As a result of today's hearing, the chairperson of the BBO gave bar counsel 24 hours to propose a path forward as to how the hearings involving Bradl and Lynn Brennan will continue. The chair of the BBO also noted Bradl's previous attempt to dismiss the ongoing complaint was denied by the chair himself. Oh, I have to write one more thing. If the hearings continue and Bradl and Brennan are sanctioned or absolved, the decision of the hearing officers will then be reviewed by the Board of Bar Overseers themselves, which is a distinct body from the Bar Council. Bar Council will in turn... there we go. So there we go. If the hearings continue and Bradl and Brennan are sanctioned or absolved, the decision of the hearing officers will then be reviewed by the Board of Bar Overseers themselves. If the case restarts with new hearing officers, evidence will once again be presented. Bradl and Brennan apparently, through their lawyers, asked a lot of questions during the first process, and that resulted in 6 days of hearings. If the case restarts with new hearing officers, evidence will once again be presented. Bradl and Brennan apparently, through their lawyers, asked a lot of questions during the first process that resulted in 6 days of hearings, and that decision would also be reviewed by the BBO. One interesting note. During today's hearing, it was disclosed that the first day of proceedings for Brennan and Bradl involved a discussion Yeah, so I just added that the move to admit the statements from the defendant that were privileged seemed to really shock bar counsel. Because that was something that came up as well. That during the first day of testimony in the matter, things were so delayed because there was a discussion about whether statements from the defendant that was, by the way, released from prison due to a bad conviction. The statements to his attorney that were privileged that Bradl apparently had should come in. I also want to note that Bradl paid the prosecution witness. Oh yeah, I included that. But it wasn't just payments, it was also round-trip flights. The payments and payments to statement, including round-trip flights. All right. Well, I really appreciate you allowing me to write that up, folks, because that was important to me. I like when I get to writing something like that, it is important to me that the way I write it reflects the way it would happen, and it happened, and this in particular has a lot of potential impact. So, okay, I've submitted that. Now you all are going to read that and be like, wow, he wasn't kidding. He really does just sit there and be like, okay, that's what happened. Let me tell people about it. Well, yeah, isn't that what you all do? I thought the whole point was to observe something happening and then just process it all, remember all of the words that they said, regurgitate it into a form that's accessible and transliterated into accessible lay English. I thought that was like, what is the point? If you're not doing it for that reason. But I also, I guess you could just be watching to see what happens, but I don't really understand. I guess I could do that, but I would be very frustrated if I was just watching something to see what happened. Like I have to be trying to interpret it or thinking about how I'm going to explain it, or I would get very bored. All right, we're going to read this document. I'm just taking the time to share this news to one of the groups because I think the content is it is actually extremely important. A lot of people follow developments related to TurtleBoy, of course, and then his lawyer, Tim Bradl, popped up in the Karen Reed courtroom the other day because Aidan TurtleBoy Kearney's phones are being pursued by Hank Brennan, and we will check, by the way, on the docket, and we'll see if any updates have happened. But for now, what I want to do is come back to this Federal Court of Appeals document, and then I'll also check your comments here for a second because I do try to keep up with them. Oh, thank you to whoever is deleting the rudeness. As a reminder, there are no exceptions to the no derogatory or discriminatory comment rule today. We occasionally do have exceptions, but out of a what do I have to fix? Oh, low sound. Hold on. It's not that there was low sound. I'm sorry about that. It's that I was typing a post in real time and I couldn't, my microphone stand was set up somewhere else right now, so I had to take the time to type it together. that I had to put my microphone down to type. Yes, so sorry about that. I'm going to go through. I know you all were saying you couldn't hear me, but yeah, I wanted to go through. Wait a minute. I didn't say, just because I said that we could have some tolerance of the rule, the exception to the rule not applying. I didn't say we could start making nice comments about the person in question. I just said we were going to exempt. No, we are not going to have an exemption today. But yes, so sorry about the, I know you all were just listening to me write my post, but I'm now actually back and we can go through the Court of Appeals document. And then also let's take a look to see if there was a ruling on the motion for the stay. I know I keep saying that, but since the ruling on the motion for the stay would preclude a lot of this because it will tell us what the First Circuit's thinking. So let me take a little bit of time and let me pay my 10 cents to load up the Pacer docket. Some people would just use Pacer Monitor, but no, I'm old school and I actually go into Pacer and I pay the 10 cents. All right, do we have a ruling? Show me a ruling. Nope, no ruling yet. Now, did anything come up on the Reed case docket? We do, of course, have a hearing in the Reed case tomorrow. It is on a litany of outstanding motions in limine. I expect some rulings from the bench tomorrow. In fact, a lot. I mean, we're going to trial. The Reed's not going to get this stay. The only thing is, actually, now that I think about it, we may have to talk this through because there's so much new discovery, in particular related to the ID investigation. That's ironic. So much discovery related to the HBO Max and investigation discovery documentary that it may actually require a delay. But the thing is, Judge Kearney tipped her hand. If we do a delay, it's going to be a 10-week delay. And I don't know, like, how badly does Hank Brennan want these ID HBO Max documentaries? He's really got to weigh that. And also, maybe we can do that during impanelment. Impanelment's going to take a while. No new documents on the Reed case either. Wow. This is odd. This is odd. The day before a hearing, nothing goes up before close of court. Let me check one other. Let's check Kearney's case here. Nope, no ruling on the motion to dismiss. All right, let's get reading. I've put it off long enough. You all are going to get me to do it. 68 pages. I should have had a coffee. I didn't. We're doing it anyway. Caleb Schillinger. I think it is Schillinger. I kept saying Schlesinger. I feel bad. I sometimes wonder if, like, Judge Kearney's listening to these streams or who, because, I mean, she's not having ex parte contact, but she can listen to whatever she wants. Because she definitely said Schlesinger the other day, and I think the reason I was saying Schlesinger was Arthur Schlesinger or something, who was, I want to say he was involved with JFK or something, but either way, I was saying that a lot. Ooh, I wonder if you heard my neck crack there. I was saying that a lot, and then his name is actually Schillinger, and I should have got that. All right, we're not going to do, I guess we can do the statement of the case just so we really understand what we're talking about, and then we're going to read the arguments, and then I'm going to become extremely educated on case law about that I already know about, but apparently we're going to learn some new case law. Oh, look at that. Love me some Bluford v. Arkansas. Arizona v. Washington. Marty Weinberg stood up and was like, you know, Your Honor, this case really starts at Arizona v. Washington, but I want to take you back to the time of the Stuart Kings. Little Towel in the audience was like, hell yeah, let's talk about the Stuart Kings. But then my brain was also like, Marty Weinberg, you better have a really, really good hook to be introducing an argument about the Stuart Kings in an American courtroom. Fiddler, I remember that one. Roth, Toohey, which is not T-O-H-U-Y, which is the other Toohey for Section 25 of the DOJ Operations and Sections Manual. McElrath, that's a big one. I love how Reed v. Commonwealth is now a precedent. Better than Tanner v. U.S. There's Tanner v. U.S. Oh, yeah, Mr. Schillinger just had a field day. This gentleman has a career ahead of him in appellate work in front of the federal courts. Somebody So that's what it is. The Attorney General represents the state in federal court. So the Attorney General's office does a lot of things, but it seems like what it also has to have is like special federal litigators. Towel likes that. Towel is a fan of specializing in federal litigation. I don't think most humans could do it, but Towel is a fan. All right. You all take a second to read the jurisdictional statement while I prepare some tobacco-based medication, and then we shall read. I know you can tell when I don't have my XL Monster Energy drink or whatever it is that I got the other day for $2 on sale. It is a lot harder for me to be like, all right, let's just do it. Especially after I just had to spend time explicating a border bar overseers hearing, which is, when I think about it, to me, it's like it's very easy to understand. I'm like, oh yeah, it's like legal discipline or whatever it is. But then I really think about it, and I'm like, oh, this is incredibly convoluted and functions like a sui generis, like administrative agency that's basically unaccountable because lawyers can't be criminally or legally charged. Like, basically, it's very hard for a lawyer doing something in the context of their representation to actually get charged with anything or get sued. So the only reason why there's so much deference to the legal profession to self-administer is because of its integrity. So I'm really interested to see if that hearing that we saw today on Tim Bradl ever goes back up on the Board of Bar Overseers YouTube. Like, was that not expected? Was that like incredibly outside of the norm to the point where it violated decorum? And like, I don't think it violated decorum, but like, did it violate the norms to the point where the chair was like, get that goddamn thing off the Vimeo? And then were they like, Mr. Chair, we tried and we did manage to get it down midstream, but then someone had already captured it. So even the people who only got half the stream got the other half. I bet when the bar count, they had like 2 likes on that video. I bet that if those things are ever public, a lot of people do not watch them. It's not like in Florida where you get like very interesting reprimands from the Supreme Court. I bet that was the most people, whether it was on this channel or across other channels, who have ever, I think there was like 900 or 1,300 on that other channel. There was at least 1,000 on this Twitter, and then another 100 of you on the YouTube, or 50 or whatever. That is by far and away the most people that have ever watched a bar counsel hearing. And I wonder if the bar counsel knew it, because whether like he saw the Twitter stream or somebody told him like, oh, like multiple people are broadcasting this. He gave a speech, that man, that Richard Abadi, that was like, it was a speech you would give if you understood you were making like a good argument to the presiding authority, but you were doing it for an audience. And I was like, I knew the implications of what I was watching in real time. But I think as this kind of like unfolds, I'm sure some news stations, well, maybe not today, but if they're smart, they'll pick up on it today. There is an undercurrent there. There is some shit there about the Sean Jenkins case and Tim Bradl and Lynn Brennan and their influence potentially over the hearing process within the Bar Counsel's office. Just some crazy stuff. If you're like, Towel, are you biting your tongue ferociously right now? You know what I have to say to you? 1, how did you figure out I do that? And 2, you're a Towel. You're not getting anything out of me. You couldn't pay me. And the weight of what I know that you don't would stun a 5-ton elephant in its tracks. Not a 10-ton elephant, but a 5-ton elephant. Where is my lighter? There's my lighter. Things have just become just outrageous in my life. Whenever we approach this trial, things get outrageous. Then there are other things going on in the cannabis world that I try to keep track of. And every day it just feels like a whirlwind of Kafka-esque chaos. And the only way I can really express my overwhelmed brain is by writing layered literary historical allusions that, for whatever reason, make me feel like, well, at least if I can express it in this way, then understanding all of this is worth it and helping people understand it. Let's begin. The petitioner, appellant Karen Reed, petitioner, appeals a final order of the United States District Court for the District of Massachusetts denying her petition for a writ of habeas corpus. The District Court had subject matter jurisdiction of the petition under 28 U.S.C. 2241. This is like a pre-trial bail provision that says for a state level offense, you're technically in custody for the purposes of a writ of habeas corpus, which means like a writ of the body or bringing the body before the court. But it's like a procedural mechanism, and you have to have some bootstrap to get federal jurisdiction, and it comes by the way of 28 U.S.C. 2241. If you were in federal custody, it would be 28 U.S.C. 2254. The petitioner is on pretrial release and remains subject to state-imposed restrictions on her liberty while awaiting retrial on criminal charges in Massachusetts State Court. By the way, you see the JA 149, 152, 516. He's citing to like a record appendix. He has to cite to every single fact that he uses has to be cited to a specific page in the record. You can't use a fact that isn't cited. And then see at the bottom, the petitioner's appellate brief is cited as petitioner brief page number. The addendum to that brief is addendum page number, and the party's joint appendix is JA. That's some shit. This must have taken this motherfucker. I bet. So he knew what he was going to respond to, but I bet he had to wait for and he knew it was expedited. He had to wait for it to go in. I bet this man spent 80 hours on this document. I bet he worked 10 to 12 hours a day between when he got the Reed brief to the First Circuit and when he wrote this. Like, this is just incredible. And I will say, let's continue. On March 13th, 2025, the District Court issued its final order and granted a certificate of appealability. As to all grounds raised in the petition, people were like, doesn't this mean that Reed's going to win her motion for stay? And isn't this a sign that she's right on the merits? And I'm sitting there like, no. A certificate of appealability just means that the district court judge thought that there was some, sorry, I'm getting my water bottle. Oh, look at that, pink and yellow. Some potential that a reasonable jurist could disagree on the nature of the facts. Nature of the disputed issue. It's very low standard, and obviously lower than a motion for stay, because Karen did not get her stay. The petitioner timely filed a notice of appeal. This court has jurisdiction of appeal pursuant to 28 U.S.C. 1291 and 2253. These are the issues presented. Number one, whether the trial judge abused her broad discretion in declaring a mistrial where the jury had deliberated nearly 30 hours over 5 days and had sent the judge 3 increasingly emphatic notes reporting that they were deadlocked. The state courts found that the jury was genuinely deadlocked. The Massachusetts Supreme Judicial Court further held as a matter of state law that inquiring about a partial verdict or polling the jury risked coercing a verdict. State law barred the judge from ordering further deliberation unless the jury consented, and the jury's third note made clear that they would not consent. And the Supreme Court has repeatedly reaffirmed that trial judges are not required as a matter of federal constitutional law to consider any particular means of breaking a jury's impasse or to take specific steps before declaring a mistrial. Now, this is how you write a statement of the issues presented in a way that is very favorable to your case. Number two, whether the trial judge erred in concluding that the petitioner consented to the mistrial where counsel did not object to the mistrial, expressed disagreement with that outcome, or asked to be heard on the matter, despite having had multiple opportunities to do so, including while counsel and the judge remained in the courtroom and scheduling further proceedings in the case because of the mistrial. What a great framing there. That may as well say David Yannetti is an idiot. Sorry, David. You know I have a mutual respect there, but that paragraph was basically a shot at David Yannetti. Now, a deserved shot, because David Yannetti precluded this entire appeal by not objecting to the mistrial. Not that the appeal wasn't precluded by 150 or 200 years or whatever, 175 years of case law, 1831. So, oh my God, it's almost been 200 years since 1831. I still live in 1990. You know, I don't know about the rest of you, but I refuse to believe we've even changed into a new century. I don't mean that literally. I'm mentally in the 1990s. Some of you are going to be like, Grant, we are well aware of that. Number three, whether the petitioner was acquitted of the charges of second-degree murder and leaving the scene, where the jury did not return, announce, and affirm any verdicts in open court. great framing. Whether the petitioner is entitled to a post-trial inquiry to probe the jurors' deliberations concerning whether there were and the nature of any votes to acquit her on 2 charges where the Supreme Court has repeatedly affirmed that jurors should not be asked to testify about the substance of their deliberations in order to protect the sanctity of those deliberations and avoid the possibility of jurors being beset by harassment, pressure, and coercion. You get 5 cents, by the way, for every error you find. I would be shocked if we find a single error in this document. Procedural history. In 2022, a Norfolk County grand jury returned 3 indictments against the petitioner, charging her with murder in the 2nd degree, master and laws 265 section 1, manslaughter while operating a motor vehicle under the influence of alcohol, MGL 265 section 13.5, and leaving the scene of personal injury resulting in death. It's injury or death, but yes, in death. Chapter 90, 24(2)(a)(2). Count 3. A jury trial on the 3 indictments began in Norfolk County Superior Court on April 16, 2024, and lasted over 2 months. On July 1, 2024, the 5th day of deliberations, the trial judge declared a mistrial based on jury deadlock. Following the mistrial, the petitioner filed a motion to dismiss counts 1 and 3 on double jeopardy grounds, or in the alternative, to conduct a post-trial jury inquiry. The motion was accompanied by 2 affidavits from her attorneys describing statements purportedly made by some jurors after the mistrial. The Commonwealth filed an opposition to the motion, and the petitioner filed a reply. The petitioner also filed 3 supplemental memoranda, each accompanied by an affidavit of counsel that included additional post-trial juror statements. On August 9th, 2024, the trial judge heard argument. On August 23rd, 2024, the judge denied the motion. This man, if this man actually wrote this, I don't know, like, if he has some help from the AG's office, I don't know what, but if this man actually wrote this man lives, sleeps, eats, and breathes this case. And I know he can't talk about it because he's a prosecutor, but this man must have an encyclopedic knowledge of this case. He must just, whoever he can talk to about it at work, he must just start saying just things about this case because he must be so overwhelmed with how much he knows. This is incredibly well done. This is not, I mean, I understand it has to be this good for the First Circuit, but you could do this as, I don't know if you need to reply to a petition for cert to SCOTUS, but this could easily go to SCOTUS. On August 23rd, 2024, the judge denied the motion. So this was the motion for what, the mistrial or something, yeah, or afterwards in Judge Kearney's court. On September 11, 2024, the petitioner filed a petition for extraordinary relief. Oh, this is how we went to the single justice who remanded to the SJC who just obliterated Reed. I remember now. So it's so interesting, actually. You can learn so much about the legal process from just tracking how this appeal happened, because it was motion, what was it? Let me get the exact motion because I just forgot what I just read. Motion to dismiss. So it was like a post-trial motion to dismiss. That gets denied. Then you use a 211.3 emergency interlocutory appeal to go to the single justice who remands to the full SJC who denies your appeal of the denied motion to dismiss, and then you can use 2241 as a hook if the client is in pretrial custody or like probation or whatever, bail. You can use that as a hook to get into federal court, and then you can ask for a review on habeas grounds of the motion to dismiss and any collateral issues. It didn't work, but if you just track how that goes up, it's fascinating. So that's how Reed gets into Judge Saylor's federal district court, whatever, last month or a couple months ago. And then Reed loses there, gets certificate of appealability, files a motion to stay the lower court proceeding, loses the stay. The certificate of appealability gets her up to the First Circuit. She gets to the First Circuit. She files this brief. This is the state's reply. Well, today she also filed a motion for a stay in the First Circuit. That's going to get denied. But you see how this is all wrapping up now? So this First Circuit's reviewing Judge Saylor's decision, who's reviewing Judge Kearney's decision. Well, excuse me. The First Circuit's reviewing Judge Saylor's decision, who's reviewing the SJC's decision and Judge Kearney's decision. And the SJC had reviewed Judge Kearney's decision already. And then the First Circuit will make its decision, probably just deny this in a one page order. I don't foresee the need to revisit Judge Saylor's learned, whatever it was, 29-page historical treatise on denying Reed's habeas petition. But then Reed, after that, is basically precluded from any more right of appeals and then has to petition the Supreme Court for certiorari on this, which they're definitely not going to do after Judge Saylor's ruling. Like, there's nothing in there for Reed to hope for. So this is the end of the line. I mean, other than the petition for a writ of certiorari to the U.S. Supreme Court, this is going to be the last bite at the apple for Reed under her automatic rights of appeal pursuant to that series of events that Mr. Schillinger or Attorney Schillinger has just laid out for us that started all the way back in the summer of 2024. Isn't this fun? Don't you want to be a federal appellate lawyer? I'm not a lawyer. I'm a towel. As you can see above my head, I'm a public information service towel, and if you want me to keep reading, please feel free to stay. You don't have to donate for that, but if you want me to stay alive, you should definitely consider donating to support this public information service that apparently so many of you find helpful, and the donation information is right above my head. Someone asked actually earlier, they sent me a message and said they couldn't read it on their phone screen. It's just my Cash App, which is Grant Smith Ellis after the money symbol, and then my Venmo is at Grant sort of dash E1, and the dash is the kind of sideways dash, you know, I think it is a dash. So yeah, I appreciate you all tuning in, and let's keep reading, because we're not even at the legal argument, the fun legal argument that I enjoy so much. So, a single justice of the SJC reserved and reported the case for a determination by the full court. On February 11, 2025, the full SJC issued a unanimous opinion affirming the trial judge's denial of the petitioner's motion. Good job with the unanimous there. Easy to miss because of how the SJC writes its opinions. On February 18, 2025, the petitioner filed in the district court, that's the federal district court, her habeas corpus petition pursuant to section 2241. The district court issued an expedited briefing and hearing schedule in light of the petitioner's retrial set to begin on April 1st, 2025. Respondent Norfolk County Superior Court, it's not actually the court, it's the district attorney's office, but the way it's styled is against the court because the court is the one that's issuing the pretrial conditions. Filed in opposition, the petitioner submitted a reply, and the district court heard oral arguments on March 5th, 2025. I was there. Those were good oral arguments. On March 13, 2025, 7 days later, the district court issued memoranda and orders denying the petition and granting a certificate of appealabilities. I used SJ's MGL 211.3 once after the Cannabis Control Commission banned me from their press conferences because I was writing an in-depth report about very serious allegations of cover-ups of abuse and things like that. I didn't get heard. But not because the court reached the merits, the single justice. It was because they deemed it not an emergency. Although I argue every second of a constitutional deprivation in the context of the First Amendment rises to that level of emergency, but can't win them all. I was also pro se. So, jury, deadlock, and mistrial. On Tuesday, June 25th, 2024, the 37th day of the petitioner's first trial, the judge charged the jury. She instructed the jury on the 3 indictments, as well as 2 lesser-included offenses of count 2, involuntary manslaughter, and motor vehicle homicide. Before deliberations began, the judge indicated that the jury would be given separate verdict slips for each of the 3 indictments. She explained to the jury the procedure for delivering the verdicts. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courthouse where the foreperson will deliver the verdicts to the court. She also instructed the jury to continue deliberating until they had reached a final verdict on each charge and not to disclose to anyone, including the judge, their progress or numerical standing before such time as they had reached a unanimous verdict. Oh, So, Karen, you were precluded this whole time from making this argument. The jury then began deliberations that same afternoon. Defendant deliberations continued over the next 3 days. On Friday, June 28th, after approximately 19 hours of deliberations, the four-person submitted a note to the judge, the first note that stated, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." Read. The Reed case site. After reading the note into the record, the judge requested argument from the parties on whether the jury had engaged in due and thorough deliberation. 3. Mass General Laws provides Chapter 234A, Section 68C. If a jury, after due and thorough deliberations, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent unless they ask from the court for some further explanation of the law. The Commonwealth argued that the jury had not had sufficient time to deliberate. I see. And that it was therefore too soon to give a Tui-Rodriguez instruction. 4. See Commonwealth v. Rodriguez, approving modified version of the charge from Tui for prospective use with deadlocked juries. The so-called Tui-Rodriguez is the Massachusetts equivalent of the federal Allen charge. It is a model instruction given when jurors report deadlock after due and thorough deliberation that is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. Once a deadlocked jury receives the Tui-Rodriguez charge or resumes their deliberations, they shall not be sent out again without their own consent. Oh, I see. So once she gave that charge, that's what Rex was referring to. Once Judge Cannoni gave that Tui-Rodriguez charge, there was pretty much an indication that if they came back one more time without a verdict, it was over. The defense disagreed and argued that the jury were communicating to the court so the defense was pushing for a mistrial. The defense disagreed and argued that the jury were communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and then that they are at an impasse. Defense counsel asked the judge to give the Tui-Rodriguez instruction. The judge determined that there had not yet, so this was after the first note, the judge determined that there had not yet been due and thorough deliberation. Given the length of the trial, the amount of evidence presented through 74 witnesses and 657 exhibits, the complexity of the issues, and the fact that each of the prior days of deliberation had been shortened, she instructed the jury to continue deliberating. Deliberations extended through that Friday afternoon and resumed the following morning, July 1st, 2024. At around 10:45 a.m. on Monday, the jury foreperson submitted another note to the judge, second note, which stated, "Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views is not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable." Yes, Mr. Thomas Jefferson. "We recognize the weight of this admission and the implications it holds." Upon reviewing this note, the judge again invited argument on whether there had been due and thorough deliberation. Although by this point the jury had already deliberated for approximately 24 to 25 hours, the Commonwealth argued it was still premature to conclude that their deliberations had been due and thorough. Defense counsel, however, had maintained that the jury had come back now twice, indicating essentially that they are hopelessly deadlocked, and that it was time for a Tui-Rodriguez. The defense again requested the Tui-Rodriguez instruction. The judge determined that the jury had engaged in due and thorough deliberation, noting that the jury had been extraordinary and that she had never seen a note like this reporting to be at an impasse. The judge gave the jury the Tui-Rodriguez instruction and sent them back to deliberate further. Later that day, at around 2:30 p.m., the foreperson submitted yet another note to the judge, third note. By that point, the jury had deliberated for approximately 28 hours. The third note stated, "Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve as to force us to compromise these deeply held beliefs. After the judge received the third note, the parties returned to the courtroom. The case was called, and the judge informed counsel that the jury is at an impasse. The jury were called back into the courtroom, and the third note was read aloud into the record. Upon reaching the final line of the note, stating that further deliberation would force the jury to compromise these deeply held beliefs, the judge addressed the jury, saying, "I am not going to do that to you folks," and she declared a mistrial. The judge discharged the jury back to the deliberation room, explaining that she would meet them there privately to thank them for their service. The judge and the parties remained in the courtroom and scheduled a date to return for a status conference. At no point during this discussion did defense counsel object to the declaration of a mistrial, express disagreement with that outcome, or ask to be heard on the matter. Purported potential post-trial juror statements. 1 week later, on July 8th, the petitioner filed her motion to dismiss, along with affidavits from her counsel. Sorry, dropped my water bottle. 1 week later, on July 8th, the petitioner filed her motion to dismiss, along with affidavits from her counsel, attorneys Alan Jackson and David Yannetti. Attorney Jackson's affidavit stated that on July 2nd, a purported juror, Juror A, contacted him. He said he was able to identify which juror they were from his conversations with them. According to Attorney Jackson, Juror A said the jury had unanimously agreed that the petitioner was not guilty of count 1, murder in the second degree, and shortly following that determination, they also had unanimously agreed that she was not guilty of count 3, leaving the scene of personal injury resulting in death. Attorney Yannetti's affidavit stated that he had received communications from 2 informants, both on July 3rd. Yes, your informants, Mr. Yannetti. He said one of these informants, Informant B, sent him a screenshot that Informant B had received from some other person, Intermediary B, of text messages that Intermediary B allegedly had received from a purported juror, Juror B. 6 degrees of Juror B. Attorney Yannetti believed he could confirm Juror B had been a deliberating juror based on a first name for Juror B given to him by Informant B, who was an Intermediary B. According to Attorney Yannetti, Juror B allegedly texted Intermediary B, who was not guilty on second degree, and split in half for the second charge. When the judge sent us back with that Hernandez thing, Tui Rodriguez, to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on the purpose, or even thought she hit him on, or no one thought she hit him on purpose, or even thought she hit him on purpose. Oh, okay. That's the same sentence. Attorney Yannetti stated that the other, who is this just random anonymous person texting, and then they're being like, oh yes, the first name, that must mean it was a juror. Attorney Yannetti stated that the other informant had contacted him to say that they personally knew a purported juror, as they and Juror C used to work together, and they had a mutual friend. Oh no, there's another intermediary who was a current co-worker and friend of Juror C. Informant C also knew from Intermediary C that Juror C would be participating in a Zoom meeting with friends to discuss the trial. 3 days later, Informant C sent Attorney Yannetti screenshots of text messages exchanged between Informant C and Intermediary C, in which Intermediary C purportedly reported what Juror C had allegedly said during the Zoom meeting. Just relaying it this way is wonderful, because any appellate judge reading this is going to be like, what was Yannetti doing? It's just so convoluted, and Schillinger is right to spell it out this way, but when you read it, it's just so convoluted. According to Attorney Yannetti, Intermediary C texted no consideration for murder 2, manslaughter started pulling at 6-6, then ended deadlock 4-8, yes. Informant C texted back, if it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? And Intermediary C responded, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on. Who are these random intermediaries? Based on the descriptions of Juror C by Informant C and Intermediary C, Attorney Yannetti said he could positively identify Juror C as a deliberating juror. This is a weird circumlocuitous route. On July 10th, Attorney Jackson submitted a supplemental affidavit stating that on July 8th, he was contacted by a purported juror, Juror D. He said he was able to identify which juror they were from his conversations with them. According to Attorney Jackson, Juror D said the jury had unanimously agreed that the petitioner was not guilty on counts 1 and 3, and that the jury's disagreement solely was on count 2 and its lesser included offenses. I don't know if I trust Mr. Jackson to relay that accurately, seeing as Mr. Jackson didn't even know what the lesser two included offenses of count 2 were, which were the count 2 was OUI manslaughter, and the lesser included offenses are manslaughter and motor vehicle homicide, well, OUI. Attorney Jackson submitted a second supplemental affidavit on July 18th. He stated that he had been contacted the day before by a purported juror, Juror E. He again said he could identify the individual as a deliberating juror. According to Attorney Jackson, Juror E said the jury was unanimous on 1 and 3. The petitioner was not guilty, and the jurors deadlocked only on the lower charges on count 2. On August 1st, 2024, the Commonwealth filed in the trial court a notice disclosing that on July 21st, an unsolicited voicemail was left on the office phone line of one of the trial prosecutors. The caller, who identified themselves as a juror by full name and seat number, stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3. That same individual left another unsolicited voicemail for the prosecutor on July 26, stating that they can confirm unanimous on charges 1 and 3 and not guilty, and as of the last vote, 9-3 on the manslaughter charges, on the lower level manslaughter charges." So it seems like you can't. On both of them, you're going to convict her on motor vehicle homicide with OUI and manslaughter? Can you do that? We need to research this. I think you have to pick one. So they were going to pick manslaughter? I mean, if it was 9-3 manslaughter, that is a really good argument for Karen keeping her driver's license and the state pleading her out on manslaughter with an upper sentencing range of 4 to 6. I mean, with the ability to appeal if Judge Kearney just goes off at sentencing and gives her like 20. Which, I mean, Karen did some pretty bad shit during the lead up to the trials, in my opinion. With Aidan and whatnot. And, I mean, I don't know what Judge Kearney's going to think about all that if we got to sentencing, but I could see that kind of deal. All right, the Commonwealth further disclosed in this notice that it had also received emails from 3 individuals who identified themselves as jurors and wished to speak anonymously. The Commonwealth had responded to the emails by stating that although it would welcome the opportunity to discuss the evidence or its case, it was ethically prohibited from inquiring into the substance of the jury's deliberation, so the Commonwealth wouldn't do it. And could not promise confidentiality, as it might be required to disclose any such communications to the defense or to the court. Yep. All 3 individuals declined to communicate further and provided no information about the jury's purported votes. Yep. All right. Hold on one second. Just seeing if there is anything that's coming up. I can't believe how bad some people are at information. Like they were just getting the information completely wrong about Bradl's disciplinary hearing today. All right, not seeing anything hugely new pop up. Keeping an eye to see if any new motions pop up. All right, let's continue. Do we read this next part? No. On August 5th, Attorney Yannetti submitted a supplemental affidavit stating that he received an unsolicited phone call on July 31st. The caller said that they had been a juror in the case, and based on what they represented to be their full name, Attorney Yannetti stated that he was able to confirm that the caller was the person identified as Juror B in his prior affidavit. According to Yannetti, the caller said the jury had reached unanimous not guilty verdicts on 1 and 3 and had been deadlocked only on 2. The caller also said they were familiar with Yannetti's prior affidavit and the text message exchanged reference to paragraph 4, except that they had meant to write, or no one thought she hit him on purpose or even knew she had hit him. I think she told her dad that she hit him, and I think she also told Yannetti that she thought she might have hit him, and I think Yannetti told someone who told Bradl, and then Bradl told Kearney in front of Lindsay Catani because Bradl is an idiot, in my opinion. The caller believed that other jurors had been reluctant to come forward because there's so much public and media attention focused on the case. That was a lot of background, which I probably read before, but if I'm going to read the motion, I'm going to do it justice and read the whole thing. And there were no errors in that whole thing. And in fact, where Schillinger found errors in like juror statements, he wouldn't even put them in the document without correcting them with like sick or brackets and then correcting the errors. This man has a methodical mind. I wonder where he went to law school. I could guess Princeton, Columbia, Yale, Harvard. Northeastern would be a little random. All right, let's continue. Summary of the arguments. Are we really on page 14? the facts take up 14 pages of this 68-page behemoth. If you're like, Grant, you really do read a lot of documents on here. Yes, I think I'm one of the few people that could just be like, well, thanks, John. John DePetro is saying, well, not everyone can go to the meeting, John. John DePetro is saying he was glad he went to the media meeting and the Karen Reed trial and was able to suggest this alternate concept. That's great. I'm thrilled, but I think I had like class. Like, not all of us can just go, but thank you for having been able to go. I appreciate that alternate arrangement. Sorry, I'm checking Twitter to see if there's like news coming up that I need to relay to you all that maybe I missed on the docket, and then I got distracted. So. But yes, if you're saying, Grant, you really enjoy reading these documents, yes, that's very true. And I will take a second to check some comments here before we get into the argument. The argument really is the most interesting part, but to do justice to Mr. Schillinger's argument, or document, this wonderful document he created that he must be very proud of. I had to read it all. Harvard grad, called it. That this man is very blatantly Harvard educated. It's one of the most obvious elements. The style is so methodical and perfectionist, and it's even more. What the hell? Oh, I dropped my phone. The style is so methodical and perfectionist that I am taken aback by it just as reading it. Thank you, Maui Swift, for dealing with whoever is causing trouble in the chat. We don't deal with rude or offensive or hurtful comments, and Maui Swift is an excellent moderator who does a good job. This isn't one of those streams where I foresee a lot of questions, though, at least until we get into the legal argument. I wouldn't say it's like bombshell developments, but it is interesting argument. The trial judge exercised sound discretion in summary of argument. The trial judge exercised sound discretion in declaring a mistrial based on the jury's deadlock, as reported in 3 increasingly emphatic notes over 5 days and nearly 30 hours of deliberation. What a great summary of that 11 pages. You really have to have a command of the facts to do that. The judge did not act rashly or prematurely. She took a measured and iterative approach, declaring a mistrial only when it became clear that the jury was genuinely deadlocked. They did not consent to continue deliberating and could not be compelled to do so, and further inquiry risked coercing a verdict. Nothing more was required here as a matter of federal constitutional law. Agreed. Irrespective. Correct use. It's either irrespective or regardless, not irregardless. Although I'm very upset because the Merriam-Webster's dictionary has updated within recent years, and now irregardless is accepted as a word. But no, irrespective or regardless. I will never use irregardless. It's an offense to, it's blue-blooded murder of the English tongue. Irrespective of whether there is a manifest necessity for the mistrial, the petitioner may be retried on counts 1 and 3 because she consented to the mistrial. That's true. Counsel, in big red letters I would write David Yannetti, counsel did not object to the mistrial, expressed disagreement with that outcome, or asked to be heard on the matter despite ample opportunity to do so, including while counsel and the judge remained in the courtroom and discussed scheduling further proceedings in the case. That was a little bit of rehashing from earlier. As the state court, I think they're forced to do this by form, though. As the state courts and the district courts correctly concluded, the petitioner was not acquitted on any charges. The jury did not return, announce, and affirm any verdicts in open court. To the contrary, their only open and public unanimous acts were their repeated statements that they were deadlocked. The alleged private, unreported, and unrecorded arguments that some of the jurors purportedly say were reached at some identified point during their deliberations are not acquittals. The district court, like the SJC, also correctly concluded that the petitioner is not entitled to a post-trial inquiry of the jurors. The proposed inquiry necessarily would require a court to delve into the substance of jury deliberations. But Massachusetts law prohibits probing the content of jury deliberations, and federal law is not to the contrary. Why a double negative? The anti-impeachment principle in Federal Rule of Evidence 606B reflects sound policy considerations that apply to deliberations generally, namely those of protecting jurors from harassment or coercion and shielding deliberations from public scrutiny to encourage frankness and freedom of discussion among the jurors. Both of these considerations are implicated here. Any inquiry would need to resolve at least 1, inconsistencies between the jurors' notes during trial and their post-trial communications, 2, inconsistencies among their post-trial communications, 3, whether any votes were tentative or part of evolving compromises, and 4, whether the jurors have experienced any post-trial pressures or influences that may affect their memories or answers to questions posed during the inquiry. Convening a post-trial inquiry to probe these topics may leave jurors reluctant to serve if they believe that their service may not end when the trial concludes, but could instead lead to future inconvenience, embarrassment, or harassment. The Constitution does not require such a result. Agreed. Argument. Standard of review. This court reviews a district court's disposition of a Section 2241 petition de novo. Completely. As a federal habeas court reviewing a petition under Section 2241, this court must defer to the SJC's finding of fact, but must undertake plenary review of that court's resolution of issues of law, quotations and citation omitted. In concluding its plenary review, however, this court is bound by and must accept the SJC's interpretations of Massachusetts law. We are similarly bound by the state's court's construction of its statutes and other issues of state law. As a matter of federal constitutional law, the trial judge exercised sound discretion in declaring a mistrial based on jury's deadlock. Here we go. A mistrial premised upon the trial judge's belief that the jury is unable to reach a verdict has long been considered... Oh, hold on. Where's the footnote? Where's this footnote 5? Why can I not find it? Did I jump over it? Is it hiding somewhere? Oh, no, I haven't gotten to it yet. A mistrial premised upon the trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial and poses no double jeopardy bar to retrial. Renico. Whoever said Renico is their favorite case, we are getting into Renico. Quotations omitted. 5. The petitioner presented no claim in the state court proceedings or in her habeas petition that the evidence at her first trial was legally insufficient to support a conviction on any of the charges which would preclude retrial. She didn't even make that argument. The decision to declare a mistrial because she didn't want the federal court to review it. The decision to declare a mistrial because of a deadlocked jury is entrusted to the trial judge's broad discretion and accorded great deference on review. In Renico, the court reiterated that the reasons for allowing the trial judge to exercise broad discretion are especially compelling in cases involving a potentially deadlocked jury because the trial court is in the best position to assess all the factors which must be considered in making a necessarily discretionary determination whether the jury will be able to reach a just verdict if it continues to deliberate. And absent such deference, trial judges might otherwise employ coercive means to break the apparent deadlock. Exactly. Thereby creating a significant risk that a verdict may result from pressures inherent in the situation rather than the considered judgment of the jurors. Renico, quoting Washington, see also Reed. Nice. Quote, trial judges receive such discretion to avoid the possibility of coercive measures being used to force jury agreements, thereby protecting the fairness of the proceedings. In addition, the court went on to reaffirm what is not required as a matter of federal constitutional law in exercising that broad discretion. We have expressly declined to require the mechanical application of any rigid formula when trial judges decide whether jury deadlock warrants a mistrial. We have also explicitly held that a trial judge declaring a mistrial is not required to make explicit findings of manifest necessity, nor to articulate on the record all the factors which inform the deliberate exercise of their discretion. And we have never required a trial judge, before declaring a mistrial based on jury deadlock, to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or to obtain the consent of either the prosecutor or defense counsel, to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. In 1981, then Justice Rehnquist, I took a class with his son, noted that this court had never overturned a trial court's declaration of a mistrial after a jury was unable to reach a verdict on the ground that the manifest necessity standard had not been met. The same remains true today, nearly 30 years later. That's true. That was very well put. The Renico case really is central to this analysis, because although the other parts, the inviolability of jury deliberations, are much more fun for me, it's the underlying broad discretion to declare a mistrial that is, you can see there, extremely broad. That really is what foreclosed Reed's argument. But learning about all the history is very interesting. Oh, nice. There's a Bluford site rejecting defendant's argument that before declaring mistrial, trial court was required to take some action, whether through partial verdict forms or other means, to allow the jury to give effect to any purported unanimity on charges despite reported deadlock, and reaffirming that, quote, we have never required a trial court before declaring a mistrial because of a hung jury to consider any particular reason of breaking the impasse. Following Renico and Bluford, this court similarly has held that trial judges are not required to take, quote, take specific steps or make specific findings before concluding that a jury is deadlocked and unlikely to reach a verdict. Yep. Rather, a judge exercises sound discretion to declare a mistrial based on deadlock so long as she takes some step to ensure that the jury truly is unable to reach a verdict before discharging it. Here, the trial judge more than satisfied this requirement. The jury's first note came after approximately 19 hours of deliberation over 4 days. In it, they stated that despite our exhaustive review of the evidence and our diligent consideration of all the disputed evidence, we have been unable to reach a unanimous verdict. The judge did not rush to declare a mistrial. Instead, she heard from the parties, and even though defense counsel insisted that the jury had already had exhausted all manner of compromise, all manner of persuasion, and were at an impasse, the judge still did not immediately declare a mistrial. She took the measured approach of considering the extent of the jury's deliberations in view of the trial length, the amount of the evidence presented, and the complexity of the issues. She concluded the deliberations had not yet been due and thorough, and she instructed the jury to continue deliberating. Now, you might be saying, why are all the facts from the facts section getting restated? Well, you can't use a fact in argument unless you state it in your facts section. So you have to state all the whole universe of facts in the facts section. And then in your argument section, you may use the facts that were already enumerated in your facts section, state them again, and then make arguments about them. It's really fun to write for federal judges. It's not. It is incredibly demanding. Let's see. So where did we cut off? All right. The jury then continued deliberating for another 5 to 6 hours, spanning Friday afternoon and the following Monday morning, before sending a second note that was noticeably more definitive. The second note stated, "We found ourselves deeply divided by fundamental differences in our opinion and state of mind, and the divergence in our views is not rooted in a lack of understanding, but deeply held convictions, and consensus is unattainable." This second note echoed language from other such cases where the SJC has characterized the jury's report of deadlock as unambiguous. Again, the jury did not race to declare a mistrial. The judge did not race to declare a mistrial. She once more gave the parties an opportunity to be heard. Defense counsel again insisted the jury were hopelessly deadlocked. Still, the judge did not declare a mistrial. Despite second note's definitive language and defense counsel's argument, judge still did not immediately conclude that all hope of attaining a verdict was lost. Instead, she gave the Tui Rodriguez charge as requested by the petitioner. After nearly 4 hours of additional deliberation, bringing the total to approximately 28 hours, the jury submitted a third note that was even more emphatic. The third note stated, "We continue to find ourselves in an impasse. Our perspectives on the evidence are starkly divided, stemming from a sincere adherence to our individual principles and moral convictions, and further deliberations would be futile and only serve to force us to compromise these deeply held beliefs." It was only then, after all of the steps described above, and in light of MGL 234A Section 68C and the tone and content of the jury's final note, that the judge declared a mistrial. In denying the petitioner's motion to dismiss, the trial judge explained that she had no doubt, based on the jury's notes to the court, that the jury were unable to reach a unanimous verdict. Nothing in the jury's 3 notes she found indicated agreement on any of the charges, or even an inkling of an indication of agreement, despite the evident care that went into writing the notes and how articulately they expressed the jurors' disagreement. It was also clear to the judge from the third note that the jurors would not consent to continuing their deliberations. And at that point, the judge was precluded by Massachusetts law, which again, remember, the federal court has to defer to if the judge is interpreting and applying Massachusetts law, from ordering the jury to continue deliberations without their consent. See MGL 234A 68C and read. District court finding that trial judge reasonably determined under the circumstances that the jury would not consent to do so. The SJC likewise found that the jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. The first and second notes provided, this is quoting the SJC, provided no indication of a partial consensus, and the third note, with its repeated references to the charges, plainly implied the opposite. That's why I was emphasizing charges earlier, because I remembered that line of the Justice George's opinion from the Reed case. In short, the record before the trial judge suggested complete deadlock. The trial judge took not just, quote, some step, but multiple steps to determine that the jury was genuinely deadlocked before declaring a mistrial. Candelario v. Santana, emphasis in original. But the trial judge and both the trial judge and the SJC found that the jury truly was unable to reach a verdict. See Reed. Considering the length of jury deliberations, the judge's prior efforts to encourage consensus, and the increasingly emphatic tone of the jury notes indicating deadlock, it was clear that the jury had reached an impasse. Federal habeas court must defer to, under Marshall, federal habeas court must defer to state court's factual findings. As the district court correctly concluded with the federal district court, the evidence that the jury was at an unresolvable impasse was substantial, and the trial judge, in the exercise of her broad discretion, made a well-grounded decision to declare a mistrial. See Renico, quoting Washington. Exercise of discretion is sound where judge does not act irrationally or irresponsibly or for reasons completely unrelated to the trial problem which purports to be the basis for the mistrial ruling. The petitioner's argument to the contrary rests on several flawed grounds. Pointing to the language in Washington, this is going to be good. Pointing to the language in Washington that the burden of justifying a mistrial rests on the prosecution, she claims the SJC and the district court improperly shifted that burden to her. But Washington explains that a deadlock jury is the type of manifest necessity sufficient to meet that burden. Indeed, it is the classic basis for a proper mistrial. Moreover, it is the type of mistrial for which the trial judge's exercise of discretion is accorded the greatest level of deference on the continuum of appellate scrutiny. Nice. The question then becomes whether the judge here abused her broad discretion in declaring a mistrial based on jury deadlock, which is exactly the question the SJC and district court addressed. There was no burden shifting. Good argument. It wasn't a burden shifting exercise to the defendant. It was just, did the judge exercise her broad discretion? And she did. The petitioner, in line with the statutory requirements and existing precedent, and she did. The petitioner further contends that the question of whether the trial judge abused her discretion reduces to 3 dispositive criteria. In Renico, the court expressly rejected the same proposition that a judge's exercise of sound discretion in the context of a deadlocked jury hinges on whether the judge heard the opinions of the parties' counsel about the propriety of the mistrial, considered the alternatives to a mistrial, and acted deliberately instead of abruptly. The court cautioned that Washington nowhere established these 3 factors as a constitutional test that determines whether a trial judge has exercised sound discretion in declaring a mistrial, nor could such factors properly be understood as merely an illumination on Washington. The court further noted that although the trial judge in the case could have asked the foreperson additional follow-up questions, granted additional time for further deliberations, or consulted with the prosecutor and defense counsel before acting, and that any of these steps would have been appropriate under the circumstances, none of these steps was required under the court's double jeopardy precedents. AKA, Karen, did Marty Weinberg either have a creative way to think he could get around this, or did he just not tell you that Renico, along with a number of other things, precluded this appeal from going anywhere? The trial judge's alleged failure here to do that, which was not required under the Constitution, is not a basis for granting habeas relief. Yes, let's say that sentence again for emphasis and because of how wonderful it is. The trial judge's alleged failure here to do that, which was not required under the Constitution, is not a basis for granting habeas relief. I love that. I love this. This man is a writer. He's not, I don't think we should have him writing fiction. I don't think we should have him writing novels of any kind. I think this man is one of the greatest legal writers I've ever seen in my entire life. And yes, a lot of these arguments are redundant for me because I read the pleadings in Judge Saylor's court. But this is even better than what was submitted in Judge Saylor's court. And I will say, oral arguments this is never getting to oral arguments, but oral arguments in front of Judge Saylor for the state of Massachusetts, or the Commonwealth of Massachusetts in this case, did not take very long because the pleadings are so strong. The arguments and the facts and the precedent are all so strong. But this legal writing is beautiful. I could not do that. If you gave me 4 months and were like, Grant, you can work on this, 3 days, 3 pages at a time, I could not produce a document like this. I would not want to produce a document like this. I would say, why are you making me write 58 pages in this perfect format? I will never in my life be able to do that. But then again, I also did not go to Harvard Law. I don't want to go to Harvard Law, and I understand now the caliber of the type of human being that comes out of Harvard Law. My father went to Harvard Law. He said that he was his description of his law school experience was that it was just nonstop and that he didn't have time to do anything but be in the library. And so when I was going into law school a few years ago, I was thinking, I'm going to be just completely swamped. And yes, 1L is extremely difficult, and there is a lot, whether you know some law or whatever, you need to read a lot. But over time, I found that I had actually encountered a substantial amount of the case law that I started running into after I really, really got the basics of Civ Pro and contracts and property and etc. A lot of the stuff I was really interested in, criminal procedure, criminal law, constitutional law, civil rights, things like that. A lot of this case law I had been engaging with and encountering, but I had not actually been contextualizing. And so law school almost became a very fun proposition for me when I realized that, because then it became this opportunity to take this wealth of historical legal knowledge and apply it within this framework that I was already interested in. But all of that's to say that is not what Harvard is like, from what I understand. You might be passionate at Harvard about the law, but they must drill those students, because I could not produce a document like this if you locked me in a room for 4 months. Yes, I think if I read a bunch of documents like this about that same case, I could probably eventually produce something like this. But this is just incredible. And this man did this. I mean, yes, he used a lot of the same material, I'm sure, from his underlying district court pleadings in front of Judge Saylor in the federal district court when he initially won down there. But my word, I think some of this was redone because it is more refined in some ways, and it's also presented for the First Circuit, so it's a little bit expanded because it includes references to Judge Saylor's ruling. So this man had to do this all over again. Which is why, despite the fact that we're 3 hours into this live stream and have much more to go in this document, in honor of this man, I'm sure he wrote it with a team, but the main author, Caleb Schillinger, of this document, by God, I'm going to read the whole thing, because it took him far more effort and skill and time to write this thing than it's going to take me to read it, even though I'm doing it out loud on a live stream. And I think over the past 3 weeks, I have read no less than 250,000 words on stream. And yes, it's helpful because I actually do need to be sitting a lot right now because I've been lightheaded. So it's actually good that I'm using this opportunity to actually engage my brain despite not being physically at my peak. Well, I haven't been physically at my peak since 2014 when I became very disabled, but recently things have been really tough. So perhaps all the sitting is good, and perhaps my vocal cords are now going to become strong to the point where I will be able to do 8-hour live streams eventually. But needless to say, let's continue. So we're picking up where why do you keep using double negatives? Is this some kind of secret code where when you're a really good legal writer you use double negatives because the judges are just okay with it? Why do you have to say not in opposite? Renico tracks. Renico is not an opposite. Why can't you just say Renico tracks? You just have a very wide lexicon, Mr. Schillinger. Despite the petitioner's suggestion to the contrary. Oh, I see. He's really saying, yeah, but you could still say Renico tracks despite the petitioner's suggestion to the contrary. Although the habeas petition in that case was brought pursuant to 2254. See, he doesn't actually say what it means, but that means that was brought in a case where the petitioner was under federal custody, not state custody. It might even be pretrial custody. I don't know. This federal pretrial custody. This court's discussion of what trial judges are not obligated to do before declaring a mistrial when the jury is at an impasse, and its rejection of a multi-factor test for determining whether a judge has excised 2254 is when you're in jail after you've been convicted of a state crime, I think. Maybe a federal crime, too. And its rejection of a multi-factor test for determining whether a judge has exercised sound discretion in declaring such a mistrial were based on the court's double jeopardy precedents, separate and apart from the additional deference required under Section 2254. Let's reread that again. Okay, so that makes sense. What they're not obligated to do. See Renico. In Bluford, the court rebuffed a similar attempt to distinguish Renico on the basis of Section 2254. There, the dissent argued, like petitioner does here, that because the mistrial question in Renico arose in the context of a 2254 case, Renico has little to say about a trial judge's responsibilities or this court's on direct review. Bluford, that was in the Sotomayor dissent. The majority opinion by Chief Justice Roberts, who also wrote for the majority in Renico. Oh, so that's why he wrote Bluford. He wrote Renico first, and then he wrote Bluford. Disagreed. So Renico must have been somewhat recent. Disagreed, noting that Renico's discussion of the applicable legal principles concerns just that, and the dissent in any event does not dispute that we have never required a trial court to consider any particular means of breaking a jury impasse. Oh, Reed's screwed here. Reed's really screwed, because this is fundamentally a Sotomayor argument. What? What? Oh, I wonder who sits for the First Circuit as the who hears petitions for cert from the First Circuit right now on the Supreme Court? Let's find out. That might actually play into... I don't think it's going to get referred, but let's at least look. Shall we? Who hears SCOTUS petitions for cert from the First Circuit? Which justice is it? Don't tell me it's Sotomayor. Yes, I know. Which justice? Yes, but the special kind of petition where you apply to a single justice and they refer it to the court. Oh, I see. So there's two different, I'm thinking about two different things. There's like a shadow docket where you need one judge who sits on the circuit to refer it to the court. And then there's this other thing, the rule of 4 for petitions for certiorari. So, I see. So how many was Renico? They must have really looked at this, because what they're really looking for, and it's never going to happen, is a re-examination of Renico and Bluford. And do they have... So Chief Justice is never going to vote for them, which means he's not going to sway Amy Coney Barrett or Kavanaugh, and there's no way Alito or Clarence Thomas are going to move on this. So you don't have anyone. Do you have a fourth vote? If you only have Sotomayor, Kagan, and who's the third? Is it still? I think Kennedy stepped down. Who's the third liberal justice? I can't believe I'm forgetting this. You only have 3 liberal justices. Breyer? No, No, Breyer stepped down. I think he did. No, he might still be there. Either way, okay, you have 3 liberals, and then you have 6 conservatives. The Alito, Thomas, Kavanaugh, Gorsuch, oh, that was the other one, Coney Barrett, and Roberts. So the question is really, can you peel off Gorsuch, Coney Barrett, or Roberts? You're not going to peel off Roberts on his own opinions in Renico and Bluford. So if you need 4 and you have the 3 liberals, you're really trying to pull off Coney Barrett, who I don't think is going to appeal unless Chief Justice Roberts would be on board with it. And then so your option is either Kavanaugh or I just listed all 6 and then forgot the other gentleman there with Kavanaugh, but either those two are really your only options because you need to get to 4. And I kind of remember the other justice that I can't believe I just mentioned his name and then forgot it, being even more of a wild card, more of a conservative. So I'm going to go through this list now and see which names I managed to say. And yeah, I got Roberts, I got Thomas, I got Alito, got Sotomayor, got Kagan. Gorsuch is the one I was thinking about. Kavanaugh, Coney Barrett. Oh, Ketanji Brown Jackson. I forgot Justice Brown Jackson, who is the newest justice. One of the newer justices. That one was hard to remember. Gorsuch, though, I don't think you're going to peel Gorsuch off either. So I'm not really sure what they're doing here. I don't really see a fourth vote on the petition for cert, and it's not going to go up on the shadow docket. So I'm just not really seeing where this is going in light of Chief Justice Roberts being so intimately involved in writing the majority holdings in Bluford and Renico, and in particular in Bluford, kind of taking, or was it Renico? Either one, taking, in Bluford, taking a shot vis-a-vis Renico at Justice Sotomayor's position that Reed's now trying to leverage. Yeah, no, I give this, so not only do I give this zero chance of the First Circuit, which is somewhat maybe like liberal, I don't foresee it going up. It's just not a position that the First Circuit can adopt in light of Bluford and Renico, even if it wanted to ideologically. And then the liberal justices on the court who might be looking to use this as a bootstrap to kind of revisit those rulings are never going to get a fourth. But I see now I finally get it. I see what Marty Weinberg is doing here. He's looking at Justice Sotomayor's dissent in Bluford, and then he's seeing that there's this itching, this extraordinary dissent for there to be a turn on this issue. He's way too early on it. Way too early. It's a 6-3 majority right now. But I see Marty Weinberg's ahead of his time in some ways. That is actually, I finally get it. I was like, what the fuck? What is Weinberg even fucking angling here for? Like, how did he even sell this? And what is his point? And the point is that he was trying to get the liberals, Ketanji Brown Jackson, Sotomayor, and Kagan, to peel off some folks on this issue. Wow, that's actually incredibly intelligent. Sorry, someone sent over a $5 donation. I just wanted to say thank you. You did not have to do that, despite the fact that I've been going for 3 hours and I'm a tired little towel. I hope you're finding the stream interesting. I'm glad that you all enjoy reading through 60-page federal appellate documents with me, and I'm glad that I can provide this public information service. It's actually why I continue to do it. I know a lot of you find this really helpful, but I'm trying to set the tone that if you're going to provide a public information service, then you should actually have it rooted not in sponsors or anything like that, but in the users. So, but yes, the other day I missed like 3 donations that came in because I wasn't looking at my phone, and then I felt guilty afterwards. So I'm just saying thank you in real time. So thank you for that. Okay. Now, where are we going? Oh, right. I had just kind of figured out about how Marty Weinberg was angling here to try to peel off a fourth vote to get a petition for cert to join the liberals who were maybe sympathetic to Sotomayor's Bluford dissent, but I don't see that happening. To be sure, this court has referenced these 3 factors post-Renico and Bluford. See United States v. Dennison, U.S. v. Gargsky. But the petitioner asked this court to go further, and in this habeas case reviewing a state high court's unanimous decision to essentially declare that they are dispositive criteria that must be satisfied to support a finding of manifest necessity. And we know that that's explicitly rejected by the court. But even putting aside Renico and Bluford, they are not. See Dennison. Quote, we caution that though these 4 factors serve only as a starting point and that our review must attend to the particular problems that confronted the trial judge, we caution, though, that these factors serve only as a starting point and that our review must attend to the particular problems that confronted the trial judge. While useful to consider those factors, they serve only as a starting point, and each case is sui generis and must be assessed on its idiosyncratic facts. Love the word sui generis. Self-generating. I think there's a Greek term as well, very hard to remember, autopoiesis. They mean similar things, but it means that it's a self-generating organism, a self-contained ecosphere, and the Schillinger's argument here is therefore trying to argue that any four factors could be dispositive within a dynamic ecosystem, as such as the test demanded under Renico, or even if setting Renico aside, under Dennison, which is a case relied on by Reed. You could not have a valid legal argument for a firm standard of four factors. It needs to be malleable, because even in that case, the factors were only a starting point. Yet, even if this court were to conclude otherwise, the petitioner still would not be entitled to relief. Under state law, reviewing courts consider whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard. As described above, and as the SJC and the district court found, the judge did consider and pursue such alternatives. After the jury's first note reporting a deadlock, the judge instructed the jury to continue deliberating. Following the second note, reporting a deadlock on even stronger terms, she issued the Tui Rodriguez instruction. It was only when the jury submitted their third reported deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent, that the judge declared a mistrial. Great applications of fact to the law here. The judge was literally compelled, based on the circumstances, to declare a mistrial. Like there was manifest necessity before that point. The defense was asking for the mistrial, and then we got to the third note, and then the judge declares the mistrial. The petitioner argues that the judge's actions in response to the first and second notes are of no moment. They concerned a separate legal issue, she claims, namely the propriety of a Tui Rodriguez instruction, and thus say nothing. Looks like Schillinger found an error because he put in brackets. Say nothing about the requisite consideration of alternatives to a mistrial. Or maybe he was removing something. But those, wouldn't you put three dots if you were like ellipses? So are you adding a space? Was say nothing a compounded word, and did Schillinger find an error in Reed's brief and therefore add in a space and put it with brackets? Looks like it. These were not unrelated issues. Instructing the jury to continue deliberating and then giving the Tui Rodriguez charge to encourage consensus among the jurors were alternatives to declaring a mistrial based on the jury's deadlock as reported in the first and second notes. They literally were the alternative. The petitioner further contends that the trial judge, in response to the jury's third note, should have inquired pursuant to Mass Rule of Criminal Procedure 27B as to the existence of any partial verdicts. The SJC, construing Mass Law, Rule 27 and 234, Mass Laws, Chapter 234A, Section 68C, and the SJC's prior precedents held that the judge was not required to make additional inquiry into the jury's deliberations, including the possibility of a partial verdict, or to poll the jurors to confirm their deadlock, and that had she done so, it would have improperly risked coercing a verdict. Yep. So what Reed was asking for is actually not required under state law. Indeed, if the judge had inquired about a partial verdict on her own initiative, and the jury returned a verdict of guilty on any of the counts, there is no question that this petitioner, Reed, would be making a strenuous and potentially meritorious argument that the guilty verdict was the product of coercive intrusion into the function of the jury. Basically saying that if Judge Kearney did what Reed is asking for in her appellate brief during the trial, and that resulted in what Reed wanted to have happening, the jurors getting, this kind of sort of partial verdict form, and then Reed was found guilty on one of those counts, Reed would be the one appealing and would probably have a meritorious argument. So what the SJC was saying, what Schillinger is emphasizing to the federal court is, of course, Judge Kearney rightfully turned down Reed's request for a partial verdict form because it would have been the very thing that Reed herself would have complained about had it gone against her. Alternatively, the petitioner claims that there would have been nothing coercive about asking the jury if they would consent to further deliberation. But this ignores the clear and emphatic language in the third note, which stated that the jury's deep division was not due to lack of effort or diligence, but rather a sincere adherence to their individual principles and moral convictions, and that to continue to deliberate would be futile and only serve to force them to compromise their deeply held beliefs. The SJC held that in these circumstances, asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial, and there is simply too great a risk that any resulting verdict would merely be the product of one hasty, final attempt to satisfy the judge's apparent desire for some form of decision on the case. And then let's check footnote 6. Oh, that got up there. That was referenced at the top. There's a distinguished here in Toribio Lugo. That case dealt with an absent juror, not a deadlocked jury, and there was an evident and viable alternative to a mistrial. The parties could have agreed to proceed with 11 jurors. All right, so not even the same type of case. As there was no federal constitutional imperative that the trial judge make those inquiries, see Renico and Bluford, the SJC's determination that further inquiry was not a viable alternative to a mistrial as a matter of state law is dispositive. That's really the heart of that argument. The SJC's already ruled on this. Even though the appellate court can review de novo, they still defer to SJC and Judge Cannoni on issues of state law. And thus it's dispositive is what Schillinger's saying. Federal habeas court bound by the state court's construction of its state statutes and other issues of state law. 7. Even if there had even if there had been an error under state law in the application of Mass Rule of Criminal Procedure 27, such a state law error alone would not be a basis for relief. As relevant here, Section 2241 does not permit relief unless a petitioner is in custody in violation of the Constitution or laws of the treaties of the U.S. 28 U.S.C. 2241, Estelle v. McGuire, affirming in Section 2254 context that federal habeas corpus relief does not lie for error of state law, and in conducting the habeas review, a federal court is limited to deciding whether a conviction violated the Constitution, laws, or treaties of the U.S. And here it's not actually a conviction, it's a mistrial, but it's really like a lower court act violated, etc. So you can't even ask for federal review of an error of state law. It has to be a federal constitutional question or federal law question or something about a treatise. Treaties. Imagine if it was treatises. Your Honor, I'm entitled to habeas review. I found this treatise written by some guy in the federal government. You can tell that, what are we at now? How many, 30 pages of double-spaced words? I'm pretty sure I'm going to end up, by the end of this reading to you all, somewhere in the vicinity of like 60,000 words. This is definitely going to be one of my records, but we're almost done. Let's see. We're getting to the downhill portion of this. Nor did the trial judge fail to provide defense counsel an opportunity to be heard. The judge solicited counsel's views after the first and second notes. As the district court observed, by the time of the second note, if not earlier, it should have been obvious to all parties that a mistrial was highly likely. That was the federal district court. Counsel had insisted, based on those notes, that the jury were at an impasse and hopelessly deadlocked. The trial judge noted that experienced counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the Tui-Rodriguez instruction, presumably was aware of the legal implications if the jury returned deadlocked again. So the federal judge was calling Yannetti an experienced trial counsel and Jackson too, and saying they should have known, they did know that they were pushing for a mistrial, and now they're complaining about the mistrial they wanted. The record does not support the petitioner's suggestion that counsel requested the Tui-Rodriguez charge, although he doesn't say charge, with no consideration that a mistrial would be declared if the jury remained at an impasse after the charge, or that counsel had no reasonable opportunity to discuss the possibility of a mistrial with the petitioner at any point during the 3-day period between the first and third note. Sorry, taking a slight breather here because I remember I wanted to post something earlier and I did end up posting it. Good for me. The trial judge, the SJC, and the district court also found that counsel had multiple opportunities to object to the declaration of a mistrial if counsel in fact wanted to do so at the time. Counsel could have objected or at least have asked to be heard on the matter. Whether counsel made a request to be heard at that moment or at some point before any final decision was made on a mistrial while waiting for the jurors to enter the courtroom, especially since the judge had announced to counsel that the jury remained at an impasse. So basically the defense never objected. The defense also could have objected or asked to be heard during the subsequent discussion with the judge about scheduling a status hearing, that was after the mistrial, or even while the jurors were still at the courthouse and waiting in the deliberation room for the judge to speak to them, that was when she was thanking them. Noting that, although this is a DePiro read and then a DePiro cite, noting that although the jury was dismissed when the mistrial was declared, upon an immediate objection, the court could have asked the jury to remain while rendering its decision. The judge further found that had counsel objected or raised an issue, she would have heard from counsel. She made a point to note that defense counsel were no shrieking violets. I remember that line. I was like, I can't believe Judge Cannoni called them no shrieking violets. I love it. Because shrinking violets, because it goes to the point, which is you were not afraid to object throughout this whole trial, and it got used against them. Not just that, but not say anything throughout the whole trial. For an illustrative example, see JA 260, 262. Oh my God, you glorious man. I am not downloading a 500-page joint appendix, even though it does only cost $3. But actually, you know what? We're going to do it. I'm going to be a towel. I'm going to go on Pacer. I am going to get this joint appendix, and we are going to see what this man is referencing. And I'm going to show you how to read a federal document, because I guarantee a First Circuit judge catching that footnote would be like, oh, yes, Mr. Schillinger, what am I going to find at JA 260 to 262 and 449? All right, where is your joint? I want the joint appendix. Is that the joint appendix? No, this is the joint appendix. How many fucking pages is this? Oh my dear God. And I need to have 2 volumes of this. Include page numbers. Yes, please do. $6. This is outrageous. What is this, a 700-page PDF? I can see why. It's 662 fucking pages. Well, I got it for you all. Well, see, if you've ever wondered why donating to this stream is a good idea, I have now lost $1 over the past hour. Because I got a $5 donation, and then I spent $6 to download you all a 662-page joint appendix just so we can see what point Caleb Schillinger is trying to make here. So I'm going to bring you up the joint appendix, which I cannot believe it was 600 pages. And then we are going to go in the joint appendix to page 260 through 262, and we are going to figure out what the hell this man is talking about. There it is. So let's jump to 200. Is it labeled? Please tell me it's labeled. All right, I think it is mostly labeled. So we want 262. Oh, okay. So thank God it's actually labeled as JA at the bottom. I would be so frustrated if I had to read this without those stamps. And we're looking for 262, you said, Mr. Schillinger? 260 to 262. Where else would you get this kind of in-depth analysis and referential overviews, folks? Who else would go into the joint appendix that's 700 pages? And then forget what page we're looking for. 260 to 262. We're almost there. What exactly happened here? What is so interesting that you had to tell? What was an example of Alan Jackson and David Yannetti not being a shrieking violet? Day 38. What day was this? Do you tell me what day it was? Let's see. What is on page? All right, here we go. So what day was this? June 26, 2024. Good morning. Oh yeah, the 3 questions. All right. Looks like there was a question from the jury. This was during deliberations. It is simply, good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So we're simply going to say yes and send it back. And then what? No objection. Okay. Entered and marked. We'll send it back. Brief recess. So why are we out here? So here we go. Your Honor, I just saw the verdict form, and as we discussed yesterday, the amendments that the court indicated it would make on the verdict forms have not been made. Oh, no. Okay, I did not say I'd make it. I said I would think about it. I said I was tired and I needed to think about it. Well, Mr. Jackson, what you said before you were tired and you needed to think about it was that you agreed that there needs to be not guilty options for the subordinate charges under count 2. I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip as submitted to the jury is exactly how it always is in Massachusetts. Mr. Jackson, can I ask you a question then? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate. The court, it's appropriate. Mr. Jackson, those are two different things. The court, it's appropriate. Mr. Jackson, let me make my argument. If you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called the lesser included. Once they decide that she's not guilty of the superior charge, now there's 2 additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter? Oh, you know what the subordinate charges were, Mr. Jackson. Anything else you want to say, Mr. Jackson? Says the court. Mr. Jackson, I'd like an answer from the court. How do they decide that she's too guilty of involuntary manslaughter on the verdict form? The court, that's their decision to make. Mr. Jackson, how do they make it if they don't have an option to check a box that says not guilty? The court, they don't check the box they say that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on top, you're left with not guilty, okay? It's so funny that you had to explain this to him. Mr. Jackson, so it's the absence of the check mark that the court determines is the not guilty finding by the jury? Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2 or 3 or 4, the verdict slip reads not guilty. Okay. Mr. Jackson, that is the court. That's how it is, Mr. Jackson. Mr. Jackson, well, apparently that's how it is going to be because that's the court ordered it, because courts ordered it. But that's not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to finding her not guilty. It's almost like the court is directing a verdict on the subordinate charges. The court, I disagree with you. Mr. Yannetti, you've seen the verdict slipped exactly like this? Mr. Yannetti, I actually haven't, Your Honor. The court, you've had no lesser includeds? Mr. Yannetti, no, we've always had lesser includeds, but I have not seen a verdict slip where not guilty is not an option for a lesser included. The court, I disagree. Mr. Jackson, and I don't see that. The court, excuse me, this is funny, Miss Reed? All right, we're done. Oh, that's why he did it. Oh, wow. I mean, yes, because it shows that Jackson's no shrieking violet, but that was the moment when Reed laughed. And now if you're the federal judge and you go read this, not only do you see it go to Schillinger's point, but the very end is Reed getting admonished for laughing. Oh, you genius man. You just absolutely genius man. I love everything about it. I love it. And that was only for an illustrative example. I love it. That was perfection. And now I want to read his other one too, 449. Since that one was so good, what did you find for us at 449, Mr. Schillinger? I hope I'm getting that right now. Doing my best. Wait, what? Oh, that was just the Pro Hoc Vice registration. You paid $355. It's not cheap to be a lawyer. All right, we're going to 449, was it? 449? 449. I think I skipped over 449. No, yeah, I skipped way over 449 because I saw a letter from the BBO, and I was like, what is that? But nothing would be in here that's that interesting. What do we got at 449? What could possibly be so interesting? What is this? What are we in the middle of? I would like to know what I'm reading, please. Oh, it's Judge Kearney's ruling on the motion to dismiss. So what could possibly be so devastating on page 449? Yep. Keep dropping my phone. All right, let's see. Just days before the declaration of a mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Attorney Jackson was not shy in informing the court that he wanted to make his argument and that the court's decision about the verdict slip was not how it should be, and it's over our strong objection. Footnote 7. And she links a YouTube video of it. Judge Kearney. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charges by not making the changes he wanted. The court finds it hard to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. There you go. Used by Judge Kearney as well. Judge Kearney didn't include the thing about Miss Reed laughing, but as such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. This man. So not only did he link to the actual exchange, but then he's like, and by the way, just to show you how honest Judge Kearney is, read the exchange and then read how she explained it in her ruling. You'll see that she's exactly right, and if anything, probably could have hammered the defense even harder in her ruling and didn't. Listen, I thought Hank Brennan was great at what he does, and he's a great trial lawyer. Don't get it wrong. He's wonderful. But this man, Caleb Schillinger, if I ever get into some position in the government, God help you all, then this man can be appointed to whatever it is he wants to do. Because, especially when it comes to legal writing, he can be the chief counsel at the CIA for all I care. This man can do wonderful things. If you can't tell, I'm doing some extensive research right now into Howard Hunt, just as a bit of an aside, because I need to take a break from reading for a second. Howard Hunt, E. Howard Hunt, who was one of the Watergate burglars. I've been tracing his separation from CIA in roughly August of 1970. And I've been following up on this really interesting guy named Wiley, who was tracking this communist newspaper that ran in the 40s, like the American Union or something. And this guy Wiley becomes like this CIA asset. And I've been going very public, they're public files, obviously disclosed. I've been going through these files, and I've been doing some research on E. Howard Hunt, and in particular, what E. Howard Hunt was doing, not only in relation to like bugging the new China news service in Havana in 1960, but also, which is itself a very fascinating episode in American history, but also, what was Howard Hunt doing between the years of 1970 and 1972 when he was working for the Watergate plumbers team, bugging Dr. Fielding's office, who was the Pentagon Papers whistleblowers lawyer, Daniel Ellsberg, psychologist. What was E. Howard Hunt doing in the years between when he separated from the agency and when the Watergate break-in happened in June of 72? I was on a serious rabbit hole about that last night. I have no idea why that just came up in what I was talking about. I must have said some name that started making me think about E. Howard Hunt. But anyway, all right. That's enough of a distraction. You can tell that my brain is just very, very tired when I try to tell an interesting story about my fascinating dive into E. Howard Hunt's life and his role as a CIA agent, and I forget why I wanted to tell the digression. All right. So Despite, we were just at footnote 8, so wherever footnote 8 is, we had already read that. That was the, okay. Defense counsel had never needed the judge to inquire whether they had an objection in order to be heard, and she had never refused them an opportunity to be heard, making it difficult for the judge to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. Despite these several opportunities, defense counsel neither objected to nor expressed any disagreement with the declaration of a mistrial. The trial judge therefore found not credible the assertions in the petitioner's motion to dismiss that the declaration of the mistrial was sudden and unexpected, or defense counsel's assertion in his affidavit in support of the motion that he lacked an opportunity to be heard. These findings and credibility determinations belie the petitioner's claim that counsel was not afforded a sufficient opportunity to be heard. The SJC additionally found that in all events, there was no indication that inviting defense counsel to participate in a third round of consultations would have produced any fruitful alternatives to a mistrial. As discussed, the judge was statutorily barred from requiring further deliberation without the jury's consent, and the third note made clear that the jury would not consent. Furthermore, nothing suggested that that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury votes. Quoting the language in the third note, the SJC observed, "It is difficult to imagine that a competent defense attorney..." This was shade, just straight shade. From the SJC to Yannetti and Jackson and the whole defense team. The SJC observed, quote, "It is difficult to imagine that a competent defense attorney, upon learning that some members of the jury, quote, firmly believed the evidence proved the elements of the charges beyond a reasonable doubt, would request that the jury be instructed to return verdicts on any charges where agreement had been reached." Exactly. The SJC was almost incredulous. Like, why would you ever ask the jury to go back to deliberations if you had indications that they were convinced that the evidence proves some elements of the charges beyond a reasonable doubt? You're just asking for a guilty verdict. Finally, and as the district court found, the trial judge cannot be said to have acted precipitatively. I love that word. Precipitatively, and without adequate time for reflection. Although the petitioner's arguments repeatedly focus in isolation on the interval of time between the receipt of the third note and the judge's declaration of a mistrial, the relevant inquiry is not confined to that interval. Of course not, because you have to consider how you got to the third note. By that point, quote, "By that point, the jury had deliberated for nearly 30 hours and had sent 3 notes to the court indicating that they were deadlocked, the latter 2 marking that point with considerable emphasis." I'd call it Jeffersonian emphasis. Far from being sudden, unexpected, or a rush to judgment, in the span of over 2 minutes, the decision to declare in the span of over 2 minutes. Did they really try to suggest that Judge Kearney made that decision in 2 minutes? It was a clear culmination of a multiple note process. The decision to declare a mistrial was, in fact, the product of a multi-day discussion between counsel and the court. Alternatively, the petitioner may be retried on counts 1 and 3 because she consented to the mistrial. The trial judge concluded that defense counsel's silence, despite ample opportunity to be heard, constituted implied consent to the mistrial. Having determined that the mistrial was manifestly necessary, the SJC and the district court did not need to reach the issue of consent, and they declined to do so. The petitioner addresses the issue in a footnote in her brief, asserting that this court should find that she did not consent because she did not affirmatively request a mistrial, and that she did not impliedly consent because she had no opportunity to object. Nonsense. As detailed above, however, counsel had ample opportunity to object, but neither did so, nor even asked to be heard concerning the material mistrial declaration, including while still in the courtroom and discussing with the judge a date for a status conference. This is sufficient to permit a finding of implied consent, which independently removes any bar to retry the petitioner, irrespective of whether there was a manifest necessity for the mistrial. Very well said. Implied consent to the mistrial. So you don't even need to get to manifest consent if there's implied consent, so this is just a backstop argument, because the manifest necessity argument, Schillinger just spent 15 pages on, nailed out of the park, and then he's like, oh, by the way, that we really won on this bigger issue anyway of the fact that the defendant implicitly consented to the mistrial. But even if you don't buy that, the we win on manifest necessity too. manifest necessity test inapplicable when the defendant had requested or effectually consented to the mistrial, and consent may be inferred from silence where a defendant had the opportunity to object and failed to do so. Yep. Karen Reed precluded her own ability to make that argument. In DePetro, the trial judge declared a mistrial sua sponte because of prejudicial error in the government's closing argument and excused the jury. Afterwards, counsel and the judge remained in the courtroom as the judge explained the reason for the mistrial. Defense counsel made a motion for judgment of acquittal, and counsel discussed with judge acceptable dates for a new trial. This court held that defense counsel had ample opportunity to object to the mistrial while in the courtroom with the judge, and because she did not object, the defendant was deemed to have consented to the mistrial. Here, too, if the petitioner objected to the mistrial or believed the judge's ruling to be in error, counsel had ample opportunity to lodge an objection or ask to be heard on the matter while conferring with the judge in the courtroom after the jury had been excused. That would have been a pertinent and appropriate subject to raise with the judge before, or at least in connection with, scheduling further proceedings in preparations for a retrial. But at no point did defense counsel do so. Contrast to Bigo Lugo, counsel had no fair opportunity to object to mistrial where she made attempts to be heard, but judge repeatedly cut her off. The petitioner, therefore, should be found to have consented to the mistrial. 9. DePetro is not distinguishable on the grounds that the petitioner argued to the district court. In particular, the court found that the counsel in that case had ample opportunity to object based solely on the discussion in the courtroom after the mistrial was declared. The court specifically noted that it did not matter whether counsel may have been on inquiry notice of the possibility of a mistrial because of an earlier conference with judges to review a transcript of the government's argument, nor was counsel's ample opportunity to object based on the courtroom discussion in combination with the other prior opportunities to object. Even absent such a reasonable expectation that counsel was on inquiry notice and should have been prepared for a potential mistrial, there was ample opportunity to object when the mistrial decision was declared by the trial court. Yeah, and so exactly, it's a case where Reed has to argue it's different than these facts, and Schillinger is saying no, it's very similar to these facts. All right, moving on to part 4. This is one of my favorite parts of the argument. I'm going to enjoy this one because it probably mentions Lawrence v. Stearns, and if it doesn't, I'll be very sad. Let's see if there's any questions. I know this is very dense legal prose, but at least if you were thinking of reading this document, if you want to see what the First Circuit's thinking about, they're certainly going to deny Reed's motion for stay and her motion on the merits, in my opinion. At least you're getting something out of this. I think it's quite useful. And we got a 600-page record appendix. So let me click over and see. Let's see. We had some questions. Someone's saying, what is this exactly? It's Karen Reed's motion to the it's the state's response to Karen Reed's current active federal appeal. Karen Reed lost her first federal appeal in the District Court for Massachusetts, the federal district court, earlier this month, so she appealed up to the First Circuit. Earlier this week, Karen lost a motion for stay by the original federal district court Judge Dennis Saylor. Reed wanted Judge Saylor to stay the lower court proceedings or put a pause to the state court proceedings, her retrial that's coming up starting on April 1st with jury impanelment, while her federal appeal was decided. However, Judge Saylor denied that stay. Now, Reed has this appeal that's still up at the federal First Circuit, right, which is one level below the Supreme Court. Reed has asked that court for a stay, too. We don't have a ruling on that motion for a stay quite yet, but we do have the actual pleadings where Reed motioned to the First Circuit to review Judge Saylor's denial of Reed's petition to try to re-examine jury deliberations from her first mistrial. You have that, and then you have the state's response to Reed's pleading. We are reading the state's response, as I mentioned, and the reason this is important is this is what the First Circuit's thinking about right now, and the pending issue, although it's a very slim possibility, because Reed submitted a motion for a stay, is if the First Circuit sees anything here, which I don't think they will, the state-level trial could be delayed. Now, there are other potential reasons why the state-level trial could be delayed, of course, in Norfolk Superior Court, having to do with all this new discovery that Hank Brennan is going to have to pursue. He just submitted a Rule 17 subpoena request to HBO Max and Investigation Discovery, the people who just produced the new 5-part Karen Reed series, docu-series about the first trial. Brennan wants 400 hours, all of the hours of interviews that the documentary crew did to produce that film. And what's shocking is I saw an interview with the producer, the president of Unsolved Productions or whatnot, who created that film. And the producer was saying, I'm so surprised that Hank Brennan did this. I just don't understand. I didn't think he would do this. We tried to not impact the public perception, and we were very down the middle. And I read that quote, and I would talk to this woman. I don't know if it was someone from her project or another project. Someone wanted me to be involved with some project over the fall or late summer of 2024. But I just didn't see the Facebook message. It went to my others folder. But when I saw that, I said, did someone just not brief this producer of this documentary for Investigation Discovery and HBO Max? Because if you know this case at all, you knew that even back during the first trial, Adam Lally and Laura McLaughlin were subpoenaing anyone that Karen had done interviews with. So if you pop in the middle of the second trial and you're doing this documentary, Hank Brennan, you had to know before you aired this that Hank Brennan was being ruthless with his Rule 17 motions to Boston 25 for the Ted Daniel interviews, to Gretchen Voss. Like, if you had followed the Voss saga at all, you would know you weren't just going to get fucking subpoenaed. You were potentially going to get hauled into court and to testify. So the fact that the HBO ID people thought that Hank Brennan was not going to subpoena them blows my fucking mind. How did you not see that coming? I could have told you that from literally day one. If you aired that documentary while the trial was still going on, he was going to subpoena you. And if there was something in there that was like really bombshell, he would literally subpoena the person who was sitting for the interview so that they can testify and authenticate it. So that's what I'm saying. There could be a delay, just to bring this back. Reed's ill-fated federal appeal is probably not going to cause a delay of the state court trial, although it could, which is why we're reading this motion to really just for me to reaffirm to myself that when the First Circuit justices are reading it, they're just going to laugh and scoff at Reed's arguments and then deny her stay and then deny the pleadings. But also, we may be looking at a delay here because of this situation with all this discovery coming in from the new documentary. And then on top of that, remember, we're looking at a minimum of 10 weeks. If we delay at all, it's a minimum of 10 weeks. That's how long Judge Kearney said it would take to re-impanel 1,200 jurors, because the last jury pool was 400. This time it's 1,200. So that's what Judge Kearney said. If we delay at all, and she would not allow the last motion for a delay from the state and Reed, it will be 10 weeks. Now, here's the thing. I'm seriously starting to think that this amount of new discovery, it's just procedurally unfair to Reed, and that's what when Judge Kearney will start getting really worried. It's procedurally unfair to Reed to have her go to trial with all of this new discovery just pouring in. Interesting. Katani Jackson Brown is assigned to the First Circuit. Let's see. How did this is now? It's not the rejected appeal. Yeah, it's the state's response to Karen appealing her rejected appeal. Let's see, a lot of questions. I'm behind and a little confused, but starving for legal documents and discussion. Don't worry, Susan. This is the state of Massachusetts. We're going to dive back into the document. This is just another round of arguments about Karen talking about her original mistrial. Back in 2024. Karen's arguing that she should be able to bring back the jurors from that trial and ask them questions about their deliberations to see which way they voted on different counts. This is an argument that really goes into the federal history and some state law history and ties it into the facts of the Reed case and explains why that is a ludicrous request. It's not even like there's a meritorious dispute at issue of fact or law here as to whether Reed's going to win. The history and the precedent, in my opinion, is so weighty for the state as to Reed losing this appeal that it's really just a pro forma exercise. However, Caleb Schillinger, who wrote this brief for the state, did an absolutely wonderful job. I'm sure he had help as well. So kudos to everyone who worked on it. But the larger implications, if you want to get quickly caught up, the reason I'm reading this is because although the chances are minuscule, the First Circuit, liberal as they are, could technically grant Reed's request for a stay, although I see that as less than 1% possible. Because there is a pending request for a stay, although the previous request for a federal stay of the state court proceedings got denied. There is a pending stay request in front of the First Circuit. It was not acted on today as far as I saw. I don't see that being granted. I don't see Reed's arguments being granted on the merits in front of the First Circuit either, and therefore the implications of this are there is a very, very slim probability, less than maybe 0.5%, that there is a delay in Reed's state-level trial because of anything to do with what's going on at the federal level. However, there is a potential that there will be a delay in Reed's state-level trial due to what's coming up tomorrow, which will be discussions about new evidence. So keep an eye tomorrow over the next 24 hours, not necessarily related to the federal issues we're discussing, but the potential for more discovery in the Reed case leading to a delay of Reed's April 1st trial. But that is also not, I think Judge Kearney will be very, 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 very reluctant to delay the April 1st trial. Now, what we will get tomorrow, by the way, just as a preview, there is a Karen Reed hearing tomorrow at 11 a.m. I'll be with you for some of it. I have commitments in the morning. I have commitments in the afternoon related to actually some very important things that I have going on as to where my coverage might go in the future. So I'm very excited about this. But I will have a little bit of time to be with you tomorrow, right in maybe a little bit of that window for some, I'm not promising all, but some of the rulings on the motions in limine, and then some of the potential oral argument, because I think Hank Brennan's going to have to go in tomorrow to this Karen Reed motion hearing and say, Your Honor, it's not that we want a delay. It's that this documentary aired. It's outside the control of either of the parties, which is true. Reed didn't control when it aired. The state had no control when it aired, and it has resulted in this new Rule 17 motion, which Your Honor is going to have to hear tomorrow. Judge Kearney is going to have to hear it. And if Judge Kearney grants or is thinking about granting the Rule 17 motion from ID Discovery and HBO Max, it's material evidence. It goes to crucial components of the state's case, and therefore it becomes a crucial component for Reed's defense to be able to review. 400 hours of fucking material. If you've watched, first of all, yes, you could break it up and take notes or whatever, but if you had a team of 3 people watching 400 hours of material, that would take you, it would take one person 400 hours. Let me see. 24 hours in a day. So times 10. So maybe like 18 days. It would take 18 days being up straight. So let's divide that. Let's times that by 3. It would take you like 55 fucking days if you were doing 8-hour days as one human to process 400 hours of material. So, in some sense, like, 10 weeks isn't that unreasonable, Judge Kearney. I mean, I'm really, if these records are that important, I don't think I kind of got a feeling I don't think we can actually go to trial as things stand for a number of reasons because of the outstanding discovery. I think the state wants to go to trial. I don't think Reed wants to go to trial. But I don't think, based on the state of the evidence right now, the incoming evidence that's still being processed through no fault of either party, that this reasonably can go to trial right now. I mean, I sound like Josh Levy, but no, not for that reason. Just because if all of the discovery up until now we're close, obviously discovery keeps going as new things come in. But if all the discovery till now were closed off, we still don't have stuff from ARCA at all. Nothing. from post February 13th as to Reed's contacts with ARCA. We are going to have to bring them back for a voir dire if they're going to testify in the middle of trial. There's this whole issue with this investigation discovery documentary that is itself this huge, outstanding discovery. There's TurtleBoy's phones. There's the issue of Brennan's consciousness of guilt instruction. I foresee 6 to 7 potential interlocutory time bombs here. Not to mention, we're not even at the point where rulings have been issued on any of these fucking things. So I think Judge Kearney reasonably has to go in tomorrow and really think through with the parties what is our plan for next week. Because as far as I can figure this out, even if we get rulings on the TurtleBoy phone motion, on the TurtleBoy going on the witness list, on the investigation discovery subpoena, do you know how long it takes? First of all, HBO Max and ID are objecting to the Rule 17 request. So that means they have an opportunity to be heard on it, technically, although I question, I guess they do have an opportunity, but it's a weird standing thing. But they definitely have an opportunity to be heard. They will bring good lawyers, as good as the Boston Globe and Boston Magazine, if not better. And what it's really going to come down to is procedurally, and based on the weight of all this discovery, I think Karen's going to get her reprieve. All my spidey towel senses are leaning strongly towards a begrudging Judge Kearney saying we probably need this 10 weeks. I think she's going to be furious, just like the first trial, and she's really not going to want to delay anymore at all. But I think we're just faced with, due to no fault of the parties, a substantial amount of incoming discovery, and then also the potential for very K-N-O-T-T-Y naughty legal issues to pop up as to Brennan's consciousness of guilt play, the TurtleBoy phones motion, which was already granted, but obviously that it's only really granted to the extent that Brennan has looked now at the material that was ordered to be turned over, obviously. But that doesn't mean Brennan has actually deployed it for the purposes of winning his request to get Kearney on the witness list or winning his consciousness of guilt motion. So all of that requires time to argue, and there could be objections raised. And it's not, at this point, even with the state kind of having tipped their hand last week by saying, listen, Your Honor, like, we consent to this request to delay this at least a little bit. That was more, I think, for the state. The state wasn't concerned about the federal appeal, which I think is meritless from Karen. I think the state was concerned about the substantial amount of discovery they have to think about. Let's see. We need to hear it. Yeah, I do agree. Hi, Jeff. No, thank you very much for engaging. We do need to hear. We do need to hear a lot of this, and I'm trying to be as informative as I can, although I'm quite tired. But yes, I promised Mr. Schillinger, although I don't know him, but in the beginning of this stream, I said, out of respect and reverence for this document, which must have taken an incredibly substantial amount of time to put together and meticulously edit. I don't think it took 400 hours, but maybe. I don't think there were 400 hours between when Reed's reply, when Reed's first circuit brief went up and when this reply was due. I don't even think there were 400 hours, but either way, this is a substantial amount of work, and I'm going to finish reading this document because I said I would. However, if you're also just tuning in and you find the content on this stream useful, which clearly some of you do, because a lot of you watch on the Twitter and a lot of you are still watching on YouTube, which is great. I'm trying to get this YouTube going a little bit more because apparently I know it is. It's easier for me to read comments on the YouTube and engage and see feedback because the Twitter comments go away. And I appreciate you if you're watching the video, if you want to give it a like or click the subscribe button. I don't have Murder by Maestro here to remind me to do so, but if you do that from within the video, it's really helpful. And then also, I spent at least like $9 today, maybe more, on Pacer documents. So anything you want to kick towards the stream, or feeding me, or helping me get pizza, or like not dying from starvation, or any number of wonderful things, I accept donations. I do this at a loss. I love this public information service, but offsetting some of the things like streaming software and Pacer documents, and it's just very appreciated. But you will never have to donate to send a comment or ask a question. That's also another principle of this stream. I think that your participation here is based on what you have to say in the comments you want to ask, and it will never be about sending donations. And this came up because some people started sending donations and saying, oh, will you read my comment because I sent you a donation? And then I had to make very clear, I will read your comment or question whether or not you send a donation, as long as it's not offensive or derogatory. All right, with that said, let's continue. Number 4, the petitioner was not acquitted on any charge because no verdict of acquittal were returned. No verdicts of acquittal were returned, announced, and affirmed by the jurors in open court. In determining whether the double jeopardy clause recognizes an event as an acquittal, the question is whether, given the operation of state law, the jury acted on their view that the prosecution had failed to prove its case, and there has been a ruling that the prosecution's proof is insufficient to establish criminal liability for an offense. McElrath. The SJC's declaration of what constitutes a valid jury verdict under the operation of state law is definitive and binding in this habeas action. The fundamental requirements for a jury's issuance of a verdict in a criminal case are set forth in Rule of Criminal Procedure 27A. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Our case law confirms that a criminal verdict is effective only when affirmed by jurors in open court. In other words, the distinction between informal agreement on a verdict and the actual return, receipt, and recording of a verdict in open court is central. Only the latter constitutes a final verdict of the jury on a criminal charge. We have consistently reaffirmed this long-standing distinction throughout our jurisprudence. Here, the jury did not return, announce, and affirm a final verdict on any charge. I swear to God, if you don't quote Lawrence v. Stearns, Mr. Schillinger, I am going to be very upset. I'm probably the only person in the world who gets upset about that. I think I'm the only person in the world who still cares about that case from 1831. But by God, they say a person dies twice, once when they pass away and once when their name is said for the last time. And I will ensure that those two human beings, Lawrence and Stearns, never have their names said for the last time while this towel walks God's green earth. Here, the jury did not return, announce, and affirm a final verdict on any charge. Their only open and public unanimous acts were their statements to the judge that they were unable to reach a unanimous verdict or to attain consensus, remained at an impasse, or were starkly divided on whether the evidence was sufficient to establish the element of the charges. Far from an affirmation in open court of unanimous agreement on counts 1 and 3, these notes clearly reflect a lack of consensus on the charges. Even if the jury's deadlock pertained specifically to count 2, their notes made no such distinction, nor did they indicate any verdict would be returned to the judge in open court as required by 27A. As such, the trial judge, the SJC, and the district court correctly ruled that the petitioner was not acquitted of any charge, quoting McElrath. In the absence of a verdict returned, received, and recorded in open court, we cannot conclude that the jury acted on their view that the prosecution had failed to prove its case. Exactly. You know what I'm looking for here. You know what site I'm excited for. Oh, someone sent another $5 donation. Thank you for that. I don't know who you are. It's anonymous. Well, it's a username, but thank you. That actually is it's very touching, especially because I was just like, I spent $6. Okay, let's continue. The requirement of an open and public verdict announced and affirmed in court is far from a mere formality, though the petitioner argues otherwise. Public affirmation in open court provides safeguards against mistakes. A Juvenile v. Commonwealth, that definitely quotes Lawrence v. Stearns. See also Commonwealth v. Zacharias. Verdict must be affirmed in open court as a unanimous act of the jury and in presence of the whole panel so that each juror may express dissent if their decision has been mistaken, misrepresented, or coerced by other jurors. It also protects each juror's right to reevaluate their position and to change their mind on any issue or their vote on any charge during deliberations. Quote, these principles recognize that as a practical matter, jurors may agree in the courthouse in the course of deliberations to a tentative compromise on the facts of a case or on the disposition of related charges as they attempt to reach unanimous agreement, and since a jury should not be precluded from reconsidering a previous vote on any issue, tentative or conditional agreements reached amid deliberations cannot have the force of a final verdict. Yep, this is key in the Reed case because the jury made agreements but never actually rendered any verdicts. In fact, the only thing they rendered were notes saying they were an impasse on charges. Indeed, under state law, even after jurors agree upon a verdict, fill out a verdict slip, and walk into the courtroom, any juror still remains free to change their mind before the verdict is affirmed and recorded. Wow, that's very interesting. See Commonwealth v. Nettis. Requiring a jury to publicly affirm their verdict in open court thus serves a vital purpose. It ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. All right. What footnotes do we have here? Where do we get where was footnote 10? Did it oh, it was up at the beginning. Yep. And then let's see footnote 11. Federal precedent does not command a different ruling here, as Bluford makes clear. The petitioner relies on several inopposite cases in which juries did return verdicts or their proceedings were terminated by judicial action. She also cites 2 cases where juries returned verdicts but filled out the verdict form incorrectly, and the courts amended the forms to correct those clerical errors. That is quite different from the situation here, where the jury never returned and affirmed any verdict showing that they had reached a final and unanimous agreement, whatever it might be, and instead repeatedly reported that they were deadlocked. In the context of cases terminated by judicial action, double jeopardy principles distinguish between a ruling on the merits and a ruling on procedural grounds. The substance of the ruling, regardless of its form or how it is styled, makes a difference. There is no such distinction with a jury determination, at least because juries do not make procedural rulings, nor does judicial action require the same safeguards that are served by the verdict and open court requirements to confirm the actual and final outcome. Yeah, so Karen, whoever cited those cases didn't do a very good job. The foreperson disclosed to the judge, this was in Bluford, in open court, in the presence of other jurors, that the jury had voted unanimously against guilt on 2 of the offenses, were deadlocked on a 3rd, and had not voted on a 4th. See Bluford. The jury continued to deliberate, later reported to the judge that they had not reached a verdict, and the judge declared a mistrial. The defendant in that case similarly argued acquittal is a matter of substance, not form, and that he had been actually acquitted of the 2 offenses based on the foreperson's earlier report of the jury's unanimous votes. The Supreme Court expressed no endorsement of his presence of substance not form, and instead rejected the argument on its own terms. Reported votes, quote, lack the finality necessary to amount to an acquittal on those offenses, quite apart from any requirement that a formal verdict be returned or judgment entered. Quote, the foreperson's report was not a final resolution of anything, the court held, because the jurors continued to deliberate after that report and therefore were free to revisit their prior votes and to change their mind. This is key for Schillinger here, because what he's saying is that even if there was some agreement among the Reed jurors, which cannot be a verdict, but even if it somehow became a verdict, it's not final under Bluford because they could have continued talking at any time. And the only final verdict was the mistrial following the 3rd note. The court further noted that it would be unjustified to assume the reported votes did not later change, given the possibility that even a single juror could have rethought their position on those offenses. Exactly right. The petitioner seeks to distinguish Bluford on the grounds that the purported juror statements at issue here supposedly reflect the jury's position at the end of their deliberations. We have no way of knowing that. For one thing, as the district court noted, a closer reading of the statements reveal that they do not actually identify at what point during the 5 days of deliberations the jury actually reached unanimous agreement on 2 of the charges. If they did at all, I added that part. They therefore do not foreclose the possibility that the supposed unanimity perceived by some jurors was based on a preliminary discussion or straw poll conducted early on or at the start of deliberations. I would say if it occurred at all. The very scenario cited by the Supreme Court is a cautionary example. Quote, a single juror's change of mind is all it takes to require the jury to reconsider. Commonwealth v. Roth. Even most recent vote immediately prior to reporting deadlock may well be tentative, a failed experiment and compromise, and not a true expression of each juror's assessment of the case. Okay, yeah, exactly. Okay, well, we feel more comfortable voting not guilty on 1 and 3 if we are going to be guilty on 2. Oh, we're 8-4 on 2. Maybe we're not so comfortable with, not guilty on 1 and 3 anymore because we don't have a compromise verdict. That's basically what the court's saying. And that's exactly why agreements aren't verdicts, because they don't reflect a verdict. They reflect an effort to get to a verdict. For another thing, the purported statements also do not and cannot establish that none of the 12 jurors would have changed their mind had the jury gone through the process of returning and affirming a verdict in open court and the solemnity that attends such an occasion. It is the rendering of a verdict that communicates the true finality and unanimity of the deliberations. And because the jury did not publicly affirm that the petitioner was not guilty of the charges, there was no acquittal barring retrial under the double jeopardy clause. 5. The petitioner's requested The petitioner's requested post-trial inquiry would require delving into the jury's deliberations, an impermissible subject. The petitioner contends in the alternative that she is entitled to a post-trial inquiry of the jurors, and the SJC and the district court rightfully rejected that contention. The requested inquiry would contravene Massachusetts law and its prohibitions on probing the content of juror deliberations, and it would be fraught with potential problems. As the SJC emphasized, maintaining the secrecy of those deliberations is a bedrock of our judicial system, which not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these foundational principles. Yep. We're not reading that footnote because it's, let's read it. Footnote 12 is from above. There's some petitioners points to additional substance, not form language in the Bluford dissent to support her position, but even the dissent considered the announcement of the 4 persons report in open court to be essential, which we did not have in Reed. That's what Schillinger's saying. And Justice Sotomayor and Bluford dissenting. And when that decision was announced in open court, it became entitled to full double jeopardy protection. Here, unlike in Bluford, any such agreement was not reported in open court in the presence of other jurors, creating further doubt on the finality of any vote. Exactly. All right, let's continue. Federal law is not to the contrary and does not compel such an inquiry to be made, notwithstanding state law. The Supreme Court has repeatedly affirmed the common law anti-impeachment principle, which is embodied in the Federal Rules of Evidence 606b1 and provides that jurors may not be asked to impeach a verdict by testifying about matters internal to their deliberations. 13. FRE 606b2 sets forth 3 exceptions to the general rule. None of these exceptions apply here. The extraneous influence cases cited in petitioner's brief are readily distinguishable. Those cases involve inquiry in certain circumstances into external or outside the courtroom matters that may impermissibly have intruded into deliberations. They rest largely on the principle that a verdict should not be based on the evidence heard in court, as described in more detail below. The inquiry proposed here goes directly to the deliberations themselves, and as one court has explained, the reasons for the distinction between extraneous and intra-jury influences on the verdict are self-evident. Outside pressures may distort the jury's deliberation to the point that its verdict results in injustice. In contrast, the give and take within the microcosm of the community leads to a verdict that is often the only way our legal system can define what it means by justice, right? So the extraneous influence cases are different than what Reed is trying to argue here. Juror may not testify, so see Wagner. Juror may not testify to remarks made by another juror during deliberations which showed that the juror at issue lied during voir dire. Wow. See Tanner. Anti-impeachment rule bars juror testimony about the consumption of drugs and alcohol by members of the jury during trial. The court, I knew that one. The court explained that substantial policy considerations give rise to the necessity of shielding jury deliberations from public scrutiny. If the rule were otherwise, the court warned jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts which might establish misconduct sufficient to set aside a verdict. Basically exactly what Reed tried to do here, and they couldn't even pull that off, so they just had to come up with this ridiculous anonymous, we acquitted her, which never was going to fly, because you need to say that in open court, and even then it probably wouldn't have been enough to say it. You have to record it on a jury form, and none of them did that. And the court continued, if evidence thus secured could be thus used, the result would be to make what was intended to be a private deliberation the constant subject of public investigation, to the destruction of all frankness and freedom of discussion and conference. This court, like the district court, should conclude that the principles and policy considerations that animate 606B apply here in the context of the jury's deliberations preceding the mistrial declaration. Additionally, it should conclude that the proposed inquiry would require a court to conduct an impermissible probe into those deliberations. We're getting to the end of the argument here, by the way, because this is the final section about why this proposed idea of a post-trial voir dire is so ridiculous. First, while the plain terms of Rule 606B admittedly speak of an inquiry into the validity of a verdict or indictment, the same policy considerations concerning the freedom of juror deliberations and the protections of jurors against harassment are unquestionably implicated in the circumstances of this case, even though it involves a mistrial. In fact, they apply with unusual force. Trials are society's way of channeling disputes into a fair and impartial resolutions, but those disputes can be bitter and emotional. Here, as the district court noted, and as discussed in more detail, the public scrutiny surrounding this case has been intense. The case has proven to be unusually divisive, and jurors already have expressed fear or a desire to remain anonymous. If the jurors were called upon to discuss their deliberations at this point, there's a strong likelihood that they would be subject to the type of harassment, pressure, and coercion that the policy underlying 606B is intended to prevent. Moreover, if the anti-impeachment principle prohibits inquiring into the deliberations that led to a guilty verdict or a defendant is being subject to punishment as the result of a conviction, it would seem incongruous to conclude that it permits inquiring into deliberations where a mistrial is declared and the defendant is not serving a prison sentence upon conviction or subject to other forms of punishment. If anything, the stakes in this scenario involving a conviction would seem higher. See also district court's decision noting that policy underlying Rule 606B that favors finality is implicated, if only by analogy, because the jury notes reporting a deadlock led inelusibly to a substantial, if not final, legal consequence, the declaration of a mistrial and the termination of the first trial. Second, the requested inquiry necessarily would entail delving into the jury's subjective reasoning and deliberative content. Although the trial judge accepted the purported juror's statements, which contained 2, 3, or even 4 levels of hearsay, as true and accurate for purposes of deciding the motion to dismiss, as did the SJC for the purposes of the appeal, the judge explicitly disagreed with the petitioner's characterization of those statements as being strong and uncontradicted. The judge found the statements directly contradicted the jury's notes during their deliberation, including their final note expressing their stark divide as to the elements of the charges. The SJC also found that the statements were inconsistent with and contradicted their prior notes. Any questioning of the jurors would need to involve questions directly targeting the content of their deliberations to resolve these inconsistencies, as the district court aptly recognized. Likewise, the deliberations would need to be probed to resolve another of the petitioner's arguments, namely her contention that the jury's reference to the charges in its final note can be readily understood to mean count 2 and its lesser included offenses. As an initial matter, this is not the more natural and straightforward reading. As an initial matter, that is not the more natural and straightforward reading. It is not what the trial judge and the SJC found it to mean, foundings that are entitled to deference here, and it is not consistent with the petitioner's position at trial. See Joint Appendix 450, trial judge noting, for the defense now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow, particularly where defense counsel had twice argued that the jury had engaged in due and thorough deliberations and could not agree. But more importantly, it does not matter what the petitioner now, in hindsight, claims the reference to the charges might mean. It matters what the jury meant at the time and why they said it. That, too, cannot be determined without inquiring into their thinking and deliberations. Furthermore, further undermining the petitioner's assertions of some form of finality and further adding to the complexity of any inquiry at this point is the inconsistency even among the jurors who are said to have made statements after trial. For example, according to Juror C, the jury were unanimous only as to second-degree murder, and the remaining charges were what they were hung on. Such a statement does not reflect unanimity on count 1 and 3. Apparently, even the 5 purported jurors, to say nothing of the 7 other jurors, were not of one mind. These and other discrepancies would need to be reconciled to establish with any confidence whether in fact or not to what extent the unanimity may have been reached. Then there's a footnote There's additional contradictions. Juror B said that following Tui Rodriguez, the deliberations turned into a bully match. Juror C, however, said that all jurors got along and it was never heated. They agreed to disagree and respected each other. Juror B also said the jury vote on count 2 was split in half. Juror C said the vote was started polling at 6-6 but ended deadlocked at 4 no 8 yes. And the purported juror who left a voicemail for the prosecutor said the final vote was 9-3 guilty. Then again, that again would require an inquiry into jurors' deliberative process, as the district court properly observed. The petitioner seeks to depict her proposed inquiry as a narrow one, directed solely to the result of the jury deliberations, and she claims that can be accomplished with a single yes or no question or series of such questions to each juror. But, as the district court aptly recognized, surely more than that would be required. I remember that. In addition to exploring the discrepancies described above, any inquiry would need to resolve whether views expressed in the jury room were tentative or offered in conjunction with what the juror believed to be an evolving compromise. A juror could not disclose where they truly stood, that is, whether any stated position was merely tentative and depended on the resolution of the other charges, on the jury's further discussion of evidence, or on some other contingency, without intruding into the heart of jury deliberations. Additional considerations militate against the requested inquiry. As the Supreme Court has recognized in the context of rescinding discharge order in civil cases, the longer the jury has been discharged, the greater the likelihood of prejudice. With passage of time, they are more likely to be exposed to potentially prejudicial sources of information or to discuss the case with others, even if they do not realize they have done so or forgot when questioned after being recalled by the court. Jurors questioned at this point, more than 8 months after they were discharged, may feel pressured to provide responses that they believe will minimize their risk of being harmed or harassed. Noting an inquiry of the jurors now would occur well after they became susceptible to outside influence. People associated with this case have been charged criminally with witness intimidation. Wow. And then we go to, what is Joint Appendix 541? Must reference Aidan Kearney. Oh, I'm glad I got the Joint Appendix, even though it cost $6. The most I've ever paid for a PACER document. You said 541. All right. 525. 541. Oh, what? Let's see. But what? You said 541. Oh, 551. $551. It's an affidavit from a jury. It's got to be a reference to the juror saying that they found out someone was charged with witness intimidation. What is this 551? Yeah, it is, but that's not the part that mentions the witness intimidation, I don't think. Where are they? It's just so confusing because it doesn't, it's 551 and then it references specifically, I thought it Oh, 541. I felt I was losing my mind. 541. And this was an order of impoundment. Oh, of jurors' names. Oh, okay. So in that order, Judge Cannoni mentions people associated with the case have been charged with intimidation. Got it. I was wondering what that was about. Let's see. One of the jurors said they fear for their personal safety and their family. They worry they'll be subject to harassment or even physical harm because of what they did or did not do on the jury and the outcome of the jury deliberations. Several of the purported jurors wish to remain anonymous. The circumstances explain why a yes or no question may not capture a juror's nuanced views or concerns, lead to a reliable and accurate understanding, or sufficiently constitute the type of solemn and formal ruling that is embodied by an actual or official verdict. After discharging jurors from their obligations and the passage of time, a judge should be reluctant to impanel a jury that has witnessed emotional reactions to its verdict. Allowing such an inquiry raises forward-looking concerns as well. The proper evidence of the decision of the jury is the verdict returned by them upon oath and affirmed in open court. It is essential to the freedom and independence of their deliberations that their discussions in the jury room should be kept secret and inviolable, and to admit testimony of jurors to what took place there would create distrust, embarrassment, and uncertainty. If jurors' deliberations are allowed to become the subject of post-trial inquiry because of purported statements like those here, future jurors may be hesitant to express their views fully and honestly during deliberations. It may also be more difficult to find jurors willing to serve, both in the retrial and in other cases where jurors know their service may not end when the trial ends, but could instead subject them to future inconvenience, embarrassment, and harassment well into the future. Simply put, the inquiry proposed here is not appropriate. There's a Sarnaev case here. Sarnaev is about the failure of the federal veneer persons to disclose information concerning potential biases during selection. It is not about, it's about a federal case. It has nothing to do with a state jury. In the end, a state jury sent 3 increasingly adamant notes reporting their deadlock. An experienced and careful state trial judge did not race to declare a mistrial. When the third note in the operation of state law made clear that the jury would not be able to reach a verdict on the charges, the judge declared a mistrial. Later purported communications from 5 jurors containing multiple levels of hearsay and at least some inconsistencies did not require the judge to conclude that the jurors' public reports of deadlock were incorrect and that not guilty verdicts had been reached on 2 of the charges. Nor did those communications require or permit her to call the jurors back and bypass well-established principles that forbid inquiring about deliberations. The Constitution does not compel a different result. The SJC so concluded, so did the district court. This court should too. 50 pages later, for the foregoing reasons, the court should affirm the decision of the district court, submitted through the Attorney General by Caleb Schillinger, Special Assistant Attorney General, who's an assistant Norfolk DA. Dear God, that was intense. It's a great argument. It's fun to read through, but 50 pages, my word, it's a treatise. It's longer than Judge Saylor's opinion denying Reed's initial motion to dismiss. But by God, if you stayed for all 4 hours, including the Bradl sanction hearing, thank you. Congratulations to you. My name's Grant Smith Ellis. I appreciate that you've been here with me. There is a Karen Reed hearing tomorrow, as I mentioned, at 11. I have a number of obligations in the morning and the afternoon, but I might have a little bit of time to do some coverage for you. Remote though it may be, I might actually have to be at school, so I might do it in the library or something to get the hearing out to you all. We'll see how that all plays out, how much time I have during the day. Thank you so much for being with me. As I mentioned, that was an exercise. I enjoyed doing it with you. I'm still talking 5 hours and 60,000 words later. I don't think any human being has actually read that brief out loud to their audience. I don't think anyone would. It was worth it, though. I hope you got some fun legal education. And let me just say a final thank you to the people who were commenting. Yes, hello. Let me be frank with you. Good to see you. Very thorough and legally sound response. I agree, Trevor McIntyre. Thank you for staying with me. I know you had read the document earlier, but you stayed through and you watched my overview. Hi, everybody. Just going to join, have to replay. Yes, Cookie Ram Lol. If you're interested in either seeing the Tim Bradl sanction hearing, which was very interesting, take a watch of that. There's definitely something underlying the surface there of one of the hearing officers potentially being conflicted in favor of Bradl and his co-prosecutor, or the prosecutor who preceded him on the case where Bradl's facing a sanction back from when he was a prosecutor, Lynn Brennan. No relation to Hank Brennan, as far as I understand. I haven't looked into it. But that is a very interesting dynamic as to why the bar council themselves thought their own hearing examiners were biased in front of Bradl, why one of those hearing officers was making comments like very obvious comments about their bias in favor of Bradl and his fellow lawyer and against bar counsel, and why that hearing examiner may have brought up bar counsel's pregnancy leave in the middle of a hearing. That's worth watching, and definitely the read through if you're interested in the Commonwealth's response to Reed's federal appeal. Okay, 4.5 hours later, I need to go. I'm exhausted. Thank you so much for watching. It was great to be with you. Thank you to the folks who sent over some $5 donations. That was great. I really appreciated that. It helped pay for the PACER documents. If you do want to send a donation, you of course can. Hopefully my voice will continue to hold up for these long streams. And for now, I'm going to go drink some water. So enjoy the rest of your Monday, folks. This turned into a way longer stream than I anticipated. You can thank Trevor McIntyre for that, who encouraged me to read the 50-page document from Caleb Schillinger. And good night, folks. It was good to be with you. I appreciate you being with me. God bless. Be well. We'll see each other soon.